Yeah, it is matter of I'm submitting the
Notes. You're for
on behalf of my learned citizen, Mr. Gautam Mr.
Sir, to this item, that was
intervene. All right. Yes.
item 1.
Item 1, Your Lordship, it's an intra-court appeal which is view of the larger bench decision now be maintainable, Your Lordship.
Right. This intra-court appeal by the state and its functionaries seeks to call in question the order dated 23/6/2023, whereby FAO number 9 of 2020 filed by you.
Yes, Your Lordship.
Filed by the appellants came to be negative on the sole ground that there was inordinate. There was an inordinate delay of 5 years and 303 days in preferring the same, and that there was no plausible explanation offered therefore. First off, as a consequence, next paragraph. Learned AGA appearing for the appellant make certain submissions seeking intervention of this court. First off, here how much delay? 431.
432.
432. Even the intra-court in the
462. No, period of delay is
even
432. Right.
Even this appeal is also preferred after brooking a long delay of 432 days. 32 days. First up, an affidavit, an application is filed in IA number 7092 of 2024, supported by an affidavit seeking its condonation. First up, a perusal of the application and the affidavit do not make out a plausible explanation for this delay too. First up, even otherwise, next paragraph. We cannot undertake examination of the matter on merits, appeal itself being not maintainable in view of DB decision.
Yes, Chip, in view of Labba Kumar Rathore State, in WA number 2047 of 2024.
Right.
Yes. I'll write.
So,
Dated 17/12/2024.
coordinate bench decision of
Larger bench.
court in this code of is it reported?
Yes, Your Lordship.
It's reported.
It is reported. Yes,
Can you give the citation? Then you write it forward. First one. Next one. In the above circumstances, the appeal is dismissed, rejected in limine. First one. Registry to send a copy of this order to the respondents. How many respondents?
One, Your Lordship.
Respondent by speed post immediately. Why there are many respondents now. Respondents immediately.
Yes, Your Lordship.
Right?
There are 12.
Well,
12.
Up.
Item 2.
Condoned it truly. But the interim order, Your Lordship says back to admission. Can you next meeting supplement this? Because they are
Going to take the in supplementary because he is seeking
85 items.
item 85 of my lord's
next.
grateful.
Item 2.
Your Lordship is a state appeal, Your Lordship. A delay of 470 days.
What is the explanation? And what is the matter on merits?
Yes, Your Lordship. This relates to pensionary benefits, Your Lordship. Here, it's a peculiar case, Your Lordship. The defendant was his assistant teacher, joined in the year 1986, Your Lordship. Then, before completion of 20 years, that is, before few months to her tenure of 20 years, she went on leave to attend to her husband who was in Kochi, Kerala at that time posted. That was around for 6 years. In the meantime, her husband gave a representation to the government saying that my wife had applied for voluntary retirement and that application has not been processed. So when the government to the concerned officer, the officer even wrote to the defendant also at that point of time that we have not received any VRS application from your end. And then, Your Lordship, she filed a writ petition. And this honorable bench of this honorable court directed that disposal of the representation in accordance to the law. There also, it was rejected that since there is no VRS, application was there. So there is no question of giving you pension or any other benefits in accordance to the VRS. Joined the service, government service as assistant teacher on 1986. 1986.
86. Then when she went away.
She went on 3/7/2006, Your Lordship. She applied for leave due to illness of her husband.
3/7/2006.
Yes, Your
But
Lordship.
by that time, she had been qualifying service for pension.
2 months short, Your Lordship. And even the government has taken a plea in between that 20 years also. For 6 years, some odd months, she was not there. She was on leave.
6 years.
6 years, odd months, Your Lordship. We have also taken that averment.
But you have not taken it as unauthorized.
No, Your Lordship. That we have not.
Unauthorized. What was she?
Assistant teacher, Your Lordship.
Assistant teacher.
Yes.
She all 20 years she has worked, even according to you. But you did not terminate her service after she abandoned it.
Yes,
At least a formal order should have been passed,
Yes.
saying that you have abandoned the service, therefore your services stand terminated.
Yes, Your Lordship. That they have not done.
That is not there.
Because at that point of time, she had come before for her VRS.
VRS.
Yes.
You
So
should have said, where is the question of VRS? You have already abandoned the service.
that, Your Lordship, there it was rejected. VRS and whatever financial and other dues, that ancillary dues that she was asking for, that a single bench had ordered. A representation was.
26/9/2019.
Yes, Your Lordship. Against that order, she had come. But she had come for a retired benefits and not for a VRS. But the single bench, Your Lordship, has decided on the VRS. That since 2013, according to section 42 of the Odisha pension rules,
What would be VRS?
3 months, within 3 months, if it is not accepted, it is accepted.
From which date VRS is accepted by the order of the court? Whether the abandoned period is also sought to be counted. That's the only point.
Yes, Your Lordship.
Other points will appeal into insignificant. You were accused when you were saying
Yes.
that not only there is no VRS application,
Yes.
but you have already left the employment
Yes.
by abandonment.
Yes, Your Lordship, the court says that the voluntary retirement application was submitted by the petitioner on 17/9/2013. That we are saying we have not received it. That also she has not challenged that communication also.
VRS dated
17/9/2013 and is deemed to have been accepted on completion of 3 months as per Rule
as per
42.
the rule itself.
Yes,
Because
but
you did not pass order.
we passed order, Your Lordship, when
After
In 19.
So, and submission. So by taking 17/12/2013 as the date of voluntary retirement of the petitioner, the OP number 4 is directed to extend the benefit of pension and other pensionary
13/12?
benefits. To 17/12/2013.
No, 79.
17/9/2013.
3 months
Sir.
Dealing with named. Right.
So, Your Lordship, the order states that
16/12/2013.
as directed to extend the benefit of pension and other pensionary benefits in terms of the provisions contained under Rule 42 of the Odisha Civil Pension Rules in favor of the petitioner. So that which I.
Right. This intra-court appeal by the state calls in question a learned single judge's order dated 17/5/2023, whereby respondent employees WPC number 13270 of 2023 having been favored, relief has been accorded to her in the following terms. It produced the condition. Next paragraph. Learned AGA appearing for the appellant submits that there is a delay of 470 days in filing the appeal, and therefore the same is accompanied by application in IA number 7148 of 2024, supported by an affidavit seeking its condonation. First off, a perusal of the application and the affidavit do not reflect a plausible explanation for the delays, for the long delay proved. Therefore, the application is liable to be rejected. First off, next paragraph. Even on facts, we do not find any ground to interfere with the order, impugned order, in as much as the respondent had made the VRS application on 17/9/2013, and no decision within the statutory limit having been taken thereon, deemed acceptance by operation of law 25, with effect from 17/12/2013, the prescribed period being 3 days. Under which rules?
Rule 42 of the OCS pension rules.
42 of OCS pension rules 929. This aspect has been rightly discussed by the learned single judge at paragraph 7 of the impugned order. Next paragraph. We agree with the same. Next paragraph. The amendment submission of learned AGA that the respondent had abandoned the services, and therefore the vinculum juris of employer-employee ceased to exist after such abandonment, and as a consequence, the respondent was not entitled to any terminal benefits, if it difficult to countenance. First off, the apex court in Tulsi Ram Patel versus Union of India, 85-54, has held that the service in public employment, although begins with contract, would escalate to the level of status, and that status would come to an end only after removal, retirement, resignation, and death in harness. First of all, merely because the appellant's assumed abandonment, court cannot hastily agree with the same. More particularly when nothing of the sort was stated in their order dated 26/9/2019, which did not accord with the request for voluntary retirement. First of all, merely saying that there is no VRS application will not be sufficient. First of all, ideally speaking, a formal order ought to be issued by the appellant to the effect that on account of abandonment of service, the employment ceased to exist. First of all. Next paragraph. In the above circumstances, the appeal being devoid of merits, even on merit, devoid of merits, and the application for condonation of delay having been negatived, comma, is liable to be rejected in limine, and accordingly it is. First, registry to send a copy of this order to the respondent immediately by speed, by petition. Yes.
Item 3.
To be acted upon, etc. Whether you have given terminal benefits already? Already given. Already given. Next.
Item 3.
What we do instead of sending that, mention his name for a
3, Your Lordship, is again a state appeal, Your Lordship.
it will not be eliminated. Once you mention his name, this is rejected and is liable to be rejected, accordingly rejected, courts having been made it. That. Yes.
So,
Item 3.
item 3 is also a state appeal, Your Lordship. The delay of 708 days.
Right now. This intra-court appeal calls in question a learned single judge's order dated 26/9/2023, whereby so many writ petitions, all by one party,
Your Lordship.
different parties.
Different. Here, Your Lordship, he was working in a work charge establishment.
Yeah.
And as
He had put in service.
more than 5 years, Your Lordship. That is what this court has held, Your Lordship, that single bench has held, that at the time of his being retrenched as a Salprus staff, he had already put in 5 years of service. So he ought to have been regularized by the authorities. But now
But in retrenching, did you pay the retrenchment compensation?
Yes, all those things were paid, and they were also
What
kept on a roster that that whenever any work would be required, they would be given employment on a preferential basis. That was also done, Your Lordship.
So how many, what is that establishment?
Work charge establishment.
Work charge establishment, part of the government only.
Yes, he was working as a helper here, Lordship, there. But now he has retired, Lordship. Now the order of regularization, he has already retired from service.
Yeah. But
So-
7,000 odd days of delay,
700 days.
700 odd days of delay.
Yes, Lordship.
Right now. This appeal by the state, this intra-court appeal by the state and its functionaries seeks to call in question a learned single judge's order dated 26/9/2022, whereby in WPC, in respondents WPC number, WPC AAC number 3655 of 2023, 2013, relief has been accorded to him in the following way. Next paragraph. Learned counsel for learned AG appearing for the appellant vehemently argues that though there is a long delay of
708 days.
708 days in filing the appeal, comma, then application in IA number 7208 of 2024, supported by an affidavit, accompanies the appeal memo, and therefore delay be condoned and appeal be heard on merits. First up, a perusal next paragraph. Having heard learned AGA and having perused the appeal papers, we decline indulgence in the matter in as much as what has been stated in the application coupled with the affidavit does not make a plausible explanation for condoning such a long delay. First up, the sages of law have said that the law that the court should not come to the aid of litigants who are sleepy and tardy. First up, upsetting the settled fact would create more mischief than allowing the same. First up. Next paragraph. In the above circumstances, the application is rejected, and as a consequence, appeal to first up. Registry to send a copy of this order to so and so forth. Have you implemented the order of the learned single judge? The order of the impugned order of the learned single judge shall be implemented within 8 weeks, within 8 weeks, in letter and spirit.
Item 4.
Lordship, item 4 and 5 relates to Sarat Chandra Pata case, that is the Hemant Chotrai case, Your Lordship, which the Honorable AG had mentioned, Your Lordship, the other day. So these two matters may be also listed.
Along with those matters.
Yes, Your Lordship.
But delay, how many days delay?
Delay, Your Lordship.
476.
428 and 476 days.
What is the explanation? We are not only 100 days, we are that too on payment of cost, we are doing more than 100 rupees, we are not 100 days. Where that will create lot many problems.
Question floor will be decided.
No,
because these cases are.
we have not decided questions of law and we will decide it in right appeals, not here. All right. So, but, yeah.
So we note, this may be placed with those cases, Your Lordship, because they're all together.
That is all right. If they are on merits, that's the question. But the delay is the threshold bar. Take down. Your government has to wake up, na? You cannot trouble the citizen by filing appeals up to 300, 400 days of delay.
Your Lordship, it will be finally heard by Your Lordship.
No question of finally.
Still then, at least be alive, Your Lordship.
No. Right.
Till then.
Right.
So,
We'll deposit the cost, Your Lordship, if.
No, 10,000 rupees.
Yes, Lordship.
All right. You file a memo saying that we are agreeable to pay cost of rupees 10,000 to the respondent within 1 week. And
that your lordship will have
Your
direct
Lordship,
pay.
you will pay.
we are not there. We want to deny relief to the state government because we will settle to 700.
Certainly, we have to pay the
We
compensation.
will abide by Your Lordship's orders. Your Lordship may order.
Because
We
now
will.
we have made a sort lot that has not improved the response of the government. We have not. If you agree 10,000 rupees, then we'll issue notice and you have to file an affidavit.
10 days,
Fine.
Your Lordship will pay. Your Lordship, we will, as a department, it will be paid, Your Lordship. We will abide by your orders.
Failing with the
Fail-
appeal may be dismissed. That's
Failing which your appeal may be dismissed.
No,
Your
but
Lordship.
long delay of 400 days, 500 days, like these appeals we are not entertaining.
There were a series of cases, Your Lordship, but for that reason, since it has not been decided, Your Lordship, hundreds of matters, Your Lordship.
I'll read our ground. What is the ground you have stated in your affidavit? Please take some. Murky ground we will not entertain at all. Individual, if applied, this has happened like this, then we can understand. We are between state and the citizen. We prefer the citizen. Yeah, that's what. Otherwise, where the you are as a state, you are entitled to do all.
Because
But
of
citizen will
the
not.
same topic, Your Lordship, that hundreds of appeals have been filed, Your Lordship. For that reason, Your Lordship, there has been this account of awaiting all the judgments, Your Lordship, the delay has happened, Your Lordship. Because that point of law had to be decided and waiting for that point of law, Your Lordship, so these delays
Issue
have happened, Your Lordship.
emergent notice, both on appeal and IA, only if the appellants deposit a lump sum, an advance cost of rupees 10,000 in the registry of this court. Registry of this court. Within 10 days, filling week, appeal run the risk of dismissal on that ground itself. First, all these appeals.
W8, 197.
Of 2024.
10 days will be over.
197 of 2024, Your Lordship. WA 197. The parent case, Your Lordship.
No, separately. First, we will decide whether you abide by your by making payment. If that we want some ground to dismiss your appeal because the way the government is doing, officers are doing, harassing the poor citizens. They are all poor people. Right?
March 2nd. So another 10 days is completed. But that,
1 second.
mm.
On the 9th, you call it. 9th of March. So, for dismissal in the event, the order is not completed. Yes, even then you may not do, but anyway, we'll Sometimes you have disappointed us by complying the orders also.
Many occasions we have also.
Item 6,
Somebody has to take chabka, otherwise work will not happen. I have seen all these things. Anyway, we are all human nature it is. Why to work is the question in Japan and other things. Why not to work is their question. If others are working, why should not I work? But here, if others are working, why I should work? That is the attitude. Yeah.
My lord, we are my lord, experiencing the lapses of the other government, not this government. This government is sincere. But your lordship has set right the trend.
Not set right, but trying to set right.
No,
We are trying to
substantially.
after we retire to chambers, that is the discussion.
In the process.
To make the bar more quality, enhancing quality of the bar, enhancing the standard of
Yes.
the government council appearing for state entities, panel council, how to enhance the performance level, how to dispose of more matters. This will be our discussion, not just sipping tea and chewing chuda and going. That way we do not do. We do a lot of work even after going.
It's a collective responsibility.
Collective responsibility. Otherwise, if we dispose of 5 matters, 6 matters per day, of course, there are very heavy matters, I can understand. What kind of matters are being done? Yes.
item 6,
My lord, this is also an appeal by the state involving some delay.
What is the order? Just so whether there is any merits in that. Because the 86 Supreme Court says,
Yes.
if there are merits
Yes.
in the main matter,
This
that is
appeal
also one of the considerations for considering the application.
for issuance of notice. My lord, there's a
How many days of delay?
delay of 396, my lord.
396.
My lord.
What is the explanation of what is the matter on merits?
Matter on merits, my lord, that's an infraction of rules. That is that the person who was not eligible to be granted with the benefit, he was only a temporary TGT teacher.
How many days he has worked?
No, not a regular lesson. This is not a regular lesson. They have the Honorable Court single judge had directed for appointment in a postgraduate teacher. In a post, law is well settled that the person who is not appointed against a particular post, he or she cannot claim for the salary of the pay of the post. My lord, he was not regularly appointed to any PGT post. He was only in ad hoc basis he was appointed. And for some temporary.
You are asking, you are not answering.
My lord, great.
What was the length of service?
The length of service, my lord. 1984, she was appointed at PGT, postgraduate teacher, whichever. So 1984 is the first appointment. Her service was extended from time to time as a trained graduate teacher while continuing as such in Regali Project High School, upgraded during 1999. Regali Project High School, Junior College, Regali Project College was established. TGT teacher
Not
including.
answering the point. How long you answer? He is not answering.
Since 1984, she was appointed.
1984. 84 to
84 to till she retired on
1999 and 91.
91.
84 to 91. Only 6-7 years.
Yes.
Yes.
Hmm.
And this
84
was
to
granted
90.
on parity. One more lecturer she was granted with this pay scale. So on parity, the Honorable Court decided to grant us this.
No, it is directed payment of annual benefits.
Yes, fine.
On what ground?
Allowed on 0.6.
How many years of service she has put in? How long she has served? What kind of performance on service law?
84 to 91.
Why your clients have not filed cases against you for recovery of damages, compensation from you, and for removal from the state role of the Bar Council for being highly incompetent? This is a service matter. In matters of pension, what will be the first question of the court? When appointed, when terminated, or when left the service? Even that you do not want to answer the question.
In
We
91,
will refer your name to the Bar Council.
91 she was.
Huh? For 7 years
she had
only.
retired.
Which days? Mr. Mishra,
My lord.
what is happened? What has happened to your bar? Any members of the bar are taken to any other high court for arguments? No. My information is no. Then how are you going to improve the state? Where from we should bring the judges for the next generation? All these kind of judges.
Yeah,
No, you have to do something. You are conducting election, fighting election, you are winning. You are most welcome, very nice. That is not the object. The object of the office bearers is to enhance the qualitative and quantitative levels of the bar members. Not for giving them freebies or giving them this, that, etc. Well, nobody, I'm not really saying anybody, really, I tell you, the Bengaluru bar, I should tell it, are superior. Bombay bar, or Madras, even Calcutta. What has happened to this? I have seen so many good people. Why they are not concentrating on studies? I tell at least 100 decisions every day in the court hall. Nobody makes note. Nobody comes and tells. That's what you have said is not correct.
There he has not seen it. He has not seen the brief. 28/8/1984 to 36/91.
That is the differential period.
Only differential, yes, he is asking for that.
1984 to
36/1991.
1991.
Nowhere your petition doesn't appear the manner it should have been drafted.
no, we are not here to please you. I have been transferred to your court not for pleasing you, for being heard. Language is not good, the law is not good, there is no performance, nobody studies, all wasting time and for everything saying, yes, my lord, yes, my lord. What we should do with that? I am not here. I have not been transferred for pleasing you people. I do not please. I don't have any intent to contest in any election. I simply retire and go. I don't expect any party also from you because it will not be worthy. Very wise people, virtuous people, if they say something, we accept it. If all Khatak market people come and put a garland, I will say no. That's not the object of life. Will you read and come, you sit down there and read. Pass over. Now, we hereafter, if poor performance is there, we may consider referring the matter to the Bar Council. We will create that history here. Mr. Mishra, we are telling it. We are warning the bar members that in the event performance is below normal, we will refer those cases to the Bar Council for removal of the registration. Otherwise, where the litigant should go? Litigants are, we are here to serve the litigants, not for doing and going, just shaking, saying everything yes to the judge. Not even one asked. Yes.
Item 7.
Item 7 also an appeal by the state involving delay of 553 days.
500?
553 days.
What is the explanation? Next time, brother, I leave you the liberty of dissent. I do not go home carrying any.
Paragraph 4 of the IA seeking
What is
condolence.
the reason, Mr. Panda? He had put in 21 years, more than 21 years of service, and you wanted to give him fresh appointment. Kindly come to para 5. Read.
No, Lordship directed him to produce certain original documents. That order is, my lord. That is, that he has not yet produced.
Yes.
23/7/2025, Lordship may see. Order dated 23/7/2025.
Yeah.
No affidavit by the respondent has yet been filed, my lord.
Reading.
Thila 27. I am to file an affidavit, or you are to file an affidavit.
The state appeal for a respondent requires. It has said 7 though. 7, item 7. 23/7/2025.
No, brother, nothing on merits. Take on. This intra-court appeal by the state and its functionaries seeks to call in question a learned single judges.
A delay has already been condoned in this matter.
They on merits we are dismissing. On
But your
19th
lordship
of
directed that order, my lord, 23/7 to produce
No, but
original.
produced now.
He has not produced.
What was produced by you? The marks and the first to contact me, so in so arranging out of this in the first which was where is the direction?
To produce certain documents, my lord.
Where is that order?
23/7.
No, that is not there. We have never directed him to do anything.
Mark as an Excel for.
We only
to
take
contain.
place on record, contact number so and so arising out of OJC number so and so. That's
It
all.
refers to that.
Not even on merits. 21 years of service, you have extended similar benefits to the other people. Though you took up the contention that it is available only to the Department of Education. But that was believed because the others also have been granted the same benefit. With learned single judge discussed in para 21, para 7.
But his initial appointment was disputed.
No, that you cannot dispute. That is not your, that was not the ground at all. You only say, for initial appointment, we needed sanction of the higher.
Yes.
That's all. You
That was
never
not
disputed
sanctioned.
that he worked for 21 years. He worked as storekeeper, being appointed under the rehabilitation assistance scheme.
Yes.
Your only contention is that entry was not facilitated by the approval of the higher authority. That is the only contention. No other contention. And government resolution dated 14th October 1998 entitles him to the benefit, not confined to any particular department.
He was even taken against vacancy.
Vacancy, taken against vacancy. He has worked 21 years. 21 years are a valuable period of any man's life.
In which post, my lord, that is also not clear.
No, he has worked as a storekeeper. No, storekeeper. If vacancy is there, this argument is not available to you.
It is on the death of the storekeeper that the vacancy arose and he was taken.
He has been inducted to that. Therefore, nothing, Mr. Panda. There is nothing. Take now. This intra-court appeal by the state seeks to lay a challenge to the learned single judge's judgment dated 19/4/2023, whereby the following relief has been bestowed on the respondent employee. Next paragraph. Learned AGA Mr. Panda vehemently argues that when the entry point itself was not sufficiently vouched with the sanction of competent authority, the length of service would pale into insignificance, and that this aspect of the matter having not been properly dealt with by the learned single judge, there is error apparent on the face of the impugned order warranting interference of this one. First one. Per contra, learned counsel appearing for the respondent employee draws our attention to the vouchable fact that the employee gained entry way back on 13 May 1988 under the Rehabilitation Assistance Scheme, semicolon. he was, that was against the vacancy in the post of storekeeper on, because of demise of the incumbent then, first time. Therefore, he contends that the appeal being unworthy of merits is liable to be rejected first time. Next, by having heard the counsel for the party and having perused the appeal paper, we broadly agree with the reasoning of the learned single judge as reflected in paragraph 6 and 7. So 7 and 10.
Yes, it's also giving the reason that how they will support the it is not resources.
7 and 10, which read as under. Next one. In the above circumstances, this appeal being unworthy of merits is likely to be rejected and accordingly first one. The appellants to implement order of the learned single judge within an outer limit of 8 weeks. 8 weeks. Yes. If already not implemented.
Item 8.
What made
No, no, item 8 is a job contract regularization matter where it has been covered by Lordship's judgment.
Yes, it's covered by myself and the Sound Sub.
Yes, Krishna Chandra Malik case. State versus Krishna Chandra Malik, WA number 17/2023. That
Just
is
write down
judgment
give a
dated.
small sheet.
Judgment dated, my lord, 15/7/2025.
There, my lords have directed regulation.
Regulations. That's true. Now, this is allowed. No, state appeal is allowed.
No, state appeal was allowed partly in consideration of the pension rules. They are eligible to minimum pension that your lordship have decided.
That is not the issue.
That is, that's not the issue.
Pension is because he was appointed only in the year 2013. Pension issue stands closed from 2004. 2005. So that will not arise here.
Now, what is the relief granted to the
Regulation.
How many years of service?
Not 6 years of service. They wanted to substitute one outsourcing person in place of the petition. The sanction vacancy.
No. I am on 8, my lord. 8 is 2, 5. I'm sorry. It's a wrong brief.
File is a file appears. Take out 8. 398 days delay.
More than a year.
Yeah.
Absolutely no explanation.
My lord, this brief, my lord, I'm sorry, my lord, so sorry. This brief is not available with me right now.
Next week.
Next week.
Yes.
Item 9.
9, my lord, is a job contract matter. That is covered by your lordship's judgment.
Covered against you.
Yes.
Covered against you. Take note.
215.
This appeal with the state, same sentence, order dated 19/7/2022.
Because it was remanded by the Hon'Ble Apex Court for fresh consideration.
16744 of 2022. On the change it pattern. Okay? Following list. Next one. The subject matter of this appeal is substantially similar to the one.
WA number 17/2023. State of Orissa for 17
of 2023.
Between State of Orissa versus Krishna Chandra Malik and others.
Heard and decided on?
On 15/7/2025. 15th of July.
May coordinate the job. We can say, may coordinate the Krishna Chandra Malik. In a bill number so and so. Heard and decided. Wide order dated so and so. First time. In the above circumstances, this appeal being devoid of merits is liable to be accordingly rejected in limine. Registration copy of this order to the OPs for information. With appellants to implement the order within an outer limit of 8 weeks without giving scope for penal action. Okay.
8 weeks limit.
8 weeks.
Item
Otherwise,
10.
one more case they will file. It goes on like this. Yeah.
Item 10.
Item 10, my lord, involving delay of 388 days, my lord.
Yeah. What is on merits?
On merits, my lord.
This is outsourcing agency.
Yes. Harassing case has been relied upon by the London single judge, where it said that the contractual employee cannot be replaced by another set
Another
of
set of the sign. So that is the right decision. After 92 Supreme Court, Kumar Baral.
Yes.
Kumar Baral.
Harassing.
Paira Singh and Kumar Baral is from your court.
Dilip Kumar Baral. Yes, Dilip Kumar Baral, BPUT University.
How many days delay?
388 days.
398 or 88?
388.
Picked up. This appeal, intercourt appeal by the state and its functionaries seeks to call in question the learned single judge's order dated 4/12/2023, whereby respondents WPC number 39243 of 2023 having been favored, the following relief has been bestowed on him or her.
Him.
Okay, produce that character. Okay, next paragraph. The appeal is preferred with a long delay of 388 days, and its condonation is sought for by filing application in IA number 664. Application number. Application in IA number
699.
699 of 2025, supported by an affidavit. First off, the explanation offered for the delay proved is not plausible, to say the least, especially when delay is too long to be condoned. First off. Next one. Even on merits, we do not find any lacuna in the order of the learned single judge, which is structured on the grand principle that one set of ad hoc employees cannot be substituted by another set. As observed by the Apex Court in State of Haryana versus Paira Singh 1992 4 ACC 118. First, the same principle has been reiterated again by the Apex Court in a pattern of decision and followed by coordinate benches of this court in a cartload of rulings. First of all. Next paragraph. In the above circumstances, the appeal being unworthy of merits is liable to be rejected, and accordingly it is eliminated. Register the appellants to implement the order of the learned single judge within an outer limit of 8 weeks without giving any scope for penal action. First, register the web copy to be acted upon. Yes, the registration copy to the respondent. It's report showing Supreme Court everywhere. Now, wherever we dismiss, if there is no advocate, the order should go to the litigant. Yes.
Item 11.
Item 11, my lord, it's an appeal by the state.
Yeah.
Involving delay of 6.
RSCP.
RSCP was wrongly granted that benefit. And with a condition that if any wrong payment is there, he is to return, and with that condition he has accepted. Now, my lord, a single judge is saying that once it is disbursed, my lord, cannot be recovered. My lord, service rule also says that if any wrong is committed, it is to be rectified.
And you want to recover it after retirement or during service only?
No, during service only.
Where? Show that. When he retired.
That in judgment.
On the ground that he has not passed the departmental examination.
Yes.
Huh. When it was sanctioned and when it was sought to be withdrawn. Sought to be withdrawn is 2018. When it was accorded to him, which date?
21st, 12, 2013.
We show that passing of a departmental examination is a sine qua non. So that's the ground on which
Two
grounds here the learned single judge just said. One is after long delay of 5 years you cannot recover because even under the Limitation Act 3 years, though the learned judge has not said it, we will add that. Now secondly, you show that for a grant of RACP benefit, passing of departmental examination is a sine qua non. So read that rule. In 1 second we will admit it now. One second case, these are all. There is one famous case in third, 2 minutes car wash company versus so and so. It is such case. Do you know that?
Paragraph 2. That paragraph.
2 minute car wash company versus so and so. A famous case which Jolovich in law of torts, Winfield and Jolovich on law of torts discuss. It is one such case. People taken by litigants are in queue. Litigants are in queue for getting the justice at the hands of courts. We have 15 years in rehabilitation cases. So many people, they should curse. They will curse the judges, if not the lawyers. Our evening of life will not be that good because the curses will govern us. Take down. The essential dispute before the learned single judge in WPC number 2318 of 2018 related to rescinding of the order dated 3/31/2013 by virtue of order dated 3/7/2018, whereby the RACP benefit granted to the employee was sought to be recovered on the ground that the extant rules prescribed passing of departmental examination as a precondition for such grant. First one, the learned single judge granted the relief to the respondent wide order dated 19/4/2023, which learned AGA is assailing before this court. Next paragraph. Having heard learned counsel for the appellant and having perused the appeal papers, and after appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge as is reflected in paragraph 4.1 and 5.1. No, as is reflected in para 6.7. Para 5.1 and 7, which read as under. First, next one. In the above circumstances, appeal being divided of so including able to be rejected, eliminate. Accordingly, it is. First off, if the impugned order shall be complied with by the appellant within an outer limit of 8 weeks without giving scope for contempt action. First off, the registrar to send a copy of this order by speed post to the respondent employer. Yes, next.
Item 12.
Next matter I seek 2 weeks time for.
All right, 2 weeks at the request of going. So finally, next.
Item 13.
13.
May I please?
Yes, sir.
13 is a state appeal. My lord, the limitation is 393 days. So for the
What is the explanation for the limitation? And what is on merits?
merits, my lord,
Yes.
petitioner was applied under.
Could not you lay your hands on that judgment? Which one? Correct. Correct. You have to read that judgment, one of the best, it was prescribed as a textbook judgment in most of the universities in England. Yes.
Applied for the post of Shiksha Sahayak in pursuance to the advertisement of 2006, my lord, which is at Annexer 1. 13/10/2006.
15/10/2006. What was his complaint before the learned single?
Complaint was on the ground of jurisdiction because he has applied twice in two places. So on that,
What was his, what he wanted? What relief has been granted to him? Let's see.
my lord, relief was granted. It is at page, my lord, page 84 for a moment.
What was that order you had made on?
Thereafter, by virtue of this Hon'Ble Court, he was adjusted in 2016. The order of the Honorable Single Judge is that to give the benefit from the date of advertisement of 2006, my lord, when he was not born in the service, my lord. That's paid 84, my lord, for a moment. That is the operating part.
13/10/2006.
Exactly.
He was deprived for claim on the ground that her residence is questionable. The candidates who were placed below her were appointed the petitioner had to rise of great fire dimension to go from one door to another to seeking this against the police first. Then multiple representatives of the only payment within their closely force on many occasions. First, it's included by full of everything wide order to something No, will not interfere. How many times she was made to come to this court? Kindly see.
3 times.
She's
Three times.
Coming to court is not a happy place.
My lord, 3 times. My humble submission only.
Say, what is your first point?
He has joined in service in 2016.
Correct. It was because of your mistake.
My lord,
All other juniors were given appointment in October 2006.
after 2006 is the advertisement.
Yes, they were given appointment in 2006.
But she has submitted 2 certificates of 2 places.
You should have immediately found out which is correct one, and on that basis, you
And
should
on
have
that
given
score,
appointment.
she has been rejected. Subsequently, writ and writ appeal. And by virtue of that writ appeal, she has given appointment in 2016. Madam.
Yeah, one more time she was in the court.
And subsequently, thrice, madam. I do
Thrice?
consider, thrice, madam. But subsequently, challenged in 2023 after lapse of near about 10 years, madam.
No, the writ appeal order was passed when?
Writ appeal was passed in 10/9/2015.
When did you implement the order?
Millard on 1/12/2016.
1/12?
2016. He joined because the order was
She filed again, she fought execution of the order.
25/6/2016 was the order and joined in 1/12/2016.
112.
1/12/2016.
112. So the order was of 19.
Order was of 10/9/2015.
10/9/2015.
First in the writ appeal. 80 of 2014.
Joined on 1/12/2016.
Order was issued in 25/6 and joined in the month of December.
No. No, we not. You were not fair to her. Firstly, she was made to come to the court thrice. Secondly, you had no justification for not undertaking the examination of 2 claims, whether this place or that place. That you could have done in 5 minutes. Your officer could have ascertained in 5 minutes. How many years?
And subsequently promoted and now regularized, also continuing as in a promoted post since 2022.
Promoted on which date?
Millard on 1/12/2019 as junior teacher. And subsequently
Retired on when?
And now it's continuing. 1/12/2022,
Ah.
he was also secondly promoted as a primary school teacher.
On 1/12/2022. 2022. Nothing. Take note.
But at the time of 2006,
No, you
neither she was
wrongly-
in that was the
We are
advertisement.
asking you whether this person, this lady, hails from X place or Y place. Two certificates she has produced. You could have undertaken an inquiry within 2 minutes case. Again, it is 3 minutes. Whether this is from any grams, the gram, that question. She would have said, she is from our panchayat. She is not from this panchayat. 3 minutes. You made her to roam in the court. For how many?
Vacancies for 1 year. That is the advertisement. Subsequently, she was adjusted and continued and promoted and getting her benefit. And that period is for 1 year, that is lapses.
No, that
Subsequently,
question will not arise. In October, pursuant to October 2006 advertisement, you have given appointment to rest of the people, but not to her. You made her to take a round here, which is not that good place it is. Therefore, learned single judge has said on that.
and after completion of
Kindly
only
come to
period
the
of 6
single
years,
judge's order,
and
Mr.
only
Monty.
complete.
Kindly come to pay, ground E.
Yes, ma'am. Read appeal number 80 of 2004.
H.
Yes.
H. Come to H. Page 76.
Yes, ma'am.
When a representation elicited no response from the authorities, the petitioner approached this court in WPC number so and so, seeking a direction so and so. The writ petition was disposed of on 7/11/2007, directing so and so. Okay, petitioner gave a representation on 14/9/2007 for implementation of the order. That was not done. Then petitioner filed a miscellaneous case number 10 of 2007 by order dated so and so, that came to be rejected. Then petitioner moved this court in WPC number so and so, seeking order to quash the order dated from possibly the collector for a direction to the opposite parties to appoint the petitioner to fix a file in Rasnagar blocks. This WPC was disposed of on 5/10/2012. Opposite part number 3 was directed to appoint the petitioner as so and so up to the merit list of 2007. When the matter was sub judice before this court, if no vacancy as per 2007 merit list would be available, then the petitioner was to be considered for appointment as Shikshak in vacancies in the educational district of Kendrapara. That you did not do. Then that order was challenged by in the WPC number now 19808 of 2000 before the division bench. Division bench allowed writ appeal.
10/2012.
Only then things moved. Then he filed contempt 542 of 2014.
Then Minal read
Kind
appeal.
of the way.
Well, fairly I am submitting at the threshold, my lord.
The contention of the admitted a compliance of it taken order number 2015. The petitioner had been engaged at the joint subsequently she was transferred to the grade in the case. The petitioner was given a designation of junior teacher. It is the case of the petitioner. The doctor have been appointed 2007. Nothing.
Yes, 7/7/2007.
She has suffered a lot in life. Only reminds me of what B.B. Shelley wrote. I fall on the thorns and I bleed. This is one such case.
And my lord, one. 6 is the advertisement, that is the order. And after completion of 6 years,
Yeah.
CR he is to be regularized. If at all the date of advertisement will be taken into consideration.
No, not of date of advertisement, but 10/7/2007.
Others have been.
When others were appointed.
7/7/2007.
And after
7/7/2007.
7. And after 6 years, is to be regularized.
Right. This appeal impugns a learned single judge's order dated 22/12/2023, whereby respondent ladies WPC number 7473 of 2023 having been favored the following relief has been accorded to her. Write down last paragraph. Go to the last paragraph. The learned judge has said that it is regrettable. There are 15 and 16. Okay? Next paragraph. Learned AGA appearing for the appellant's vehemently contend that the advertisement was of October 2006. The respondent, to vouch her local credentials, had produced 2 certificates, and therefore, after examining the same, the authorities did not favor her claim. Personally, he further submits that after too many rounds of litigation, the respondent was accorded appointment with order dated
1/12/2016 may not join.
No, order is June. You said some June. So
That is on
order was
25 June 2016.
25 June 2016. And the respondent joined duty on
1st December 2016.
16. First time. He further adds that when the very appointment is in June 2016, learned single judge is absolutely not justified in making her appointment with effect from 7/7/2007. First time. Therefore, he seeks indulgence of this court in the impugned order. First, ready be seated. Having heard a learned AG and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge. First, the advertisement was of 13/10/2006, semicolon. Selection having been made, others were given appointment with order dated 7/7/2007. Whereas that benefit was denied to the respondent unjustifiably, only on the ground that she had produced 2 documents of 2 different places to vouch her credentials as to local Haley residents. First one. Whether 2 certificates are spurious or one of them is, could have been ascertained in minutes, if not days. First one. However, that did not happen in this case. First one. The respondent was made to come before the court in a plethora of litigations, and ultimately she got appointment order dated 25/5/2016. That too after the threat of contempt proceedings. First one. She joined duty on 1/12/2016. 1/12/2016. First one. Next paragraph. Learned single judge at paragraph uh, 12, 13, and 14 has observed as under. First one. Below that, after that, we are in complete agreement with the learned single judge. And we also share the anguish which he has expressed by a pen dipped in acid while writing the impugned judgment. First one. the state should conduct itself as a model employer, said the apex court in Bhupendranath Acharika versus State of Assam, 2013. 2013. So, however, the case of the appellants does not make it that way. First off, it had the appellants had treated the poor employee in a very bad way, and poor lady employee in a very bad way. First off, a welfare state would not do that. Like this, a constitutionally ordained welfare state cannot afford to do that. First time. Next one. In the above circumstances, appeal being unworthy of merit is liable to be rejected, and accordingly it is in limine. First up, perfect to be sent to impugned order to be anything to be implemented in that. Impugned order to be implemented by the appellants within an outer limit of 8 weeks. Failing which
Only the
for the delay.
operating part. Operating part is the consequential benefits.
Yes, whether have you given it?
And the area pay.
Yes.
As he is continuing in
Within a
service.
period of 8 weeks. Failing which
He has to
delay.
pay 3 months because he is continuing
3
in
months.
service.
Delay 3 months. And delay may attract heavy costs on daily basis payable by the erring officials if an application is moved by the respondent employee. If for us, yes. Now, no cost. Okay. No cost will be arranged because they were not issued notice. Yes. Yes. Have you prepared now? You should not mistake our words. I have nothing to lose but just by smiling and denying relief to you. You should not mistake the advice of the court, the appeal of the court, the request of the court. Okay?
I'm sorry.
Even when it is coached in a bad language, ignore the linguistic part. Let's see with and substance of the speech. Yes.
Item 6.
Yes, Mr. Panda.
Well,
Say the facts.
well, the paragraph 1 of the
That delay there.
In delay.
Yes.
One more ground for our declining interference is that the appeal has been preferred after seeking a long delay of
393.
393 days. In person, an application is by affidavit in IA number joint with moved, taking its condonation. First off, this delay is too long and the explanation offered is not plausible. First off, therefore, the third application is rejected. One more. Yes.
page 10, your lordship may kindly have a page.
No.
Page 10, running page 10 of the brief. That the improved order, para 3, it clearly states that the claim was for the benefit of the scale of pay attached to the post of the postgraduate chemistry teacher for a period 1984 to 36/1991 for 7 years. That he was claiming the
Chemistry teacher,
yes,
PG chemistry teacher.
PG chemistry teacher.
Chemistry teacher.
And our only contention was she was working on an ad hoc basis. It was not a regular posting. Regular post she was not working.
Well, that was during the period between 14/8/84.
84 to 36/1991.
For that period, she was entitled to
A scale of pay. That she was
Scale of
claiming.
pay.
Yes.
whether her appointment was pursuant to advertisement.
No.
Where have you stated? In the writ petition. Where have you stated?
In the writ petition.
You can't improve your appeal here. What is the stand you had taken before the learned single judge? That will be the stand you have to duplicate here.
Yes.
Because learned single judge decides on a particular stand taken by you,
Yes.
or by no stand taken by you. Here you cannot take up a particular stand that you did not take up before the learned single judge.
Come to us.
Yes. How was the mode of appointment? You answer, your time. We'll give you some more time. You come some other day. All right. But don't waste time again. Mr. Panda, I have been telling right from the day one that lawyers should prepare a chit, which Bhulabai Desai used to do, Sir Firoz Shah Mehta used to do, which Palkiwala used to copy. They used to prepare a chit. Date of appointment, in this case. Mode of appointment. Date on which promotion has been granted. Date on which the salary pay scale orders have been extended. No checks. We are not Palkiwalas. We know our stage.
My lord, we have filed the technical. It is there.
Everything is necessary. Na? Otherwise, how are you going to lay down ideas before the younger members of the bar? They will look at you. Turning pages here is called in Sanskrit Yuddha Kale Shastrabhyase. That will not help you. Yes. Call week after next for coming with more preparation. For the bar to come with more preparation. Yes.
Item 14.
Regarding this intra-court appeal, there has been delay of 592 days.
Your appeal.
And yes, and I have explained the delay in my discuss seeking condonation of the same in paragraph 5.4, 5, 7, 9. This petition, the order of disengagement passed against this appellant was grossly violative of principles of natural justice, and the same was passed without affording her any opportunity of hearing.
Case of unauthorized absence.
Yes.
Yes.
Unauthorized absence.
Under circumstances that
When were you appointed? When were you appointed?
by the order under Annexure 1 in the year 2011,
Give the date.
yes,
Not year.
on 20 order dated 24/11, and pursuant to that, she joined on 27/4/11. Order dated 24/11 on Annexure 1.
April 2011.
Yes. And pursuant to that, she did join in her post on 27/4/11.
Yeah.
Because in that order of engagement, there was a condition. At the time of appointment, she was a BSc graduate. She was directed to complete her BD within a period of 5 years as an in-service candidate.
Slowly. 5-year gestation period.
Yes, 5 years from the date of engagement, she was to complete her BD as an in-service candidate. And in terms of said condition, the appellant completed the BD
When?
during the period from 9/6/12 to 17/7/15.
From.
From,
It cannot be from. So
Completed
court
on.
say it should be on a particular date.
yes, 17/7/15. 17/7/15, training period over and passed. The training
1
certificate.
second.
17/7/15
The past BD.
BD, and that certificate stands annexed on Annexure 4 at page 18.
The 4 page
18, Milord.
Board of Secondary Education on this secondary education.
Diploma elementary education, diploma elementary education, elementary, and she underwent that course in DT Gajpati Palakhemudi.
No, this is not BD or it is equivalent.
Diploma, that is equivalent.
Equivalent. So
Equivalent.
it is not BD.
That is
Direct.
the diploma in education, that is equivalent to BD.
Take us
And-
where it says BED or diploma in so and so, so and so. Where is that requirement?
Milord, in Annexure 1 at page 15, clause 9 at the bottom, it
Nine.
stated,
1 second.
Milord,
She-
page 15.
1 second. She must complete training in CT stroke BD. What is
BD?
CT? Huh?
CT oblique BD.
See, what is meant by CT?
CT is certificate training, that is a certificate training. and bachelor in education. Bachelor in the
No, that we can do. Where is the certificate of training?
that is at annexure 4 on page 18.
No. This is either city or BD.
This is BD.
This is BD.
This BD.
So you say that this elementary course that you undertook is equivalent to BD.
Yes, BD.
Where is that?
Equivalent.
Is it equivalent?
Equivalent.
No, it's equivalent certificate. That is the
Equivalent
point.
certificate. She was sent for training as a reservist candidate by the opposite party.
After this,
Yes. After completing that course, when she went to the school for joining, she was not allowed by the headmaster, saying that you are not coming. And in fact, at the time of the initial engagement, gross violation was made by the opposite parties in appointing her, because there was a counseling was to be made, her option was to be taken by them while posting. But she was posted in a far off place 130 kilometers away from her husband place, because her husband was serving as a teacher in the JNU Jawaharlal Nehru
Navodaya Vidyalaya.
school. So she was staying there. Option should have been taken by the authority. However, they did not do that. They posted her in a far off place. And when she made objection, she raised her grievance that I am posted in a far off place. How can I make up and down to the school? They said your grievance will be considered. You go and join fast.
Where is that?
Yes, and that I have stated so. And accordingly, she joined. And thereafter, she applied for training, and accordingly, she was sent for a training. After
Sorry. 20 April 2011 is the date of order.
Yes,
27/4/2011 is the joining date.
yes.
When you actually reported for duty,
Millard,
where did you report for duty?
on 20, your lordship can see annexure 3 at page 17.
Yes, did it.
This is the joining report.
Where did she join?
She joined in the school.
Where?
That is the initial joining.
Where?
She joined in Gobindapur. With due respect, I have to inform that this is the letter of headmaster of Upper Primary School, Gobindapur, informing the opinion number 3 that she has joined the school. Thereafter, she was sent for training.
She was sent for training.
That document that I have taken averment to that effect. She was sent for training, and after completion of the training, your lordship may kindly turn to in para 7 at page 6 of the petition. It is stated that the appellant, in terms of the aforesaid clause of order of engagement dated 24/11, applied for undergoing training in diploma in elementary education, and she, having been selected by the authority as per the prescribed procedure, completed such training as an in-service candidate during the period from 9/6/12 to 17/7/15. The certificate showing the appellant to have passed the diploma in elementary education is enclosed at annexure 4. That after completion of training, the appellant proceeded to her school to resume her work, but she was not allowed by the headmaster of Upper Primary School, Gobindapur, for which
Read your representation. You said
she made representation under annexure
5. Yes.
5. But this annexure, this representation was not looked into, and it was kept pending. And what happened? She was staying in her husband's place. It was totally inconvenient for her to make up and down. When her grievance was not looked into, she was not in a position to make up and down. And this
you had given a representation.
representation was not considered, and under the circumstances, she could not go. And when she could not attend the duty. This was the practical situation. But
How long she could not attend?
After completion of training in the year 2015 up to the year 2000, till the order of disengagement was passed
On
2010-2020.
Yes, 2010, 2020.
10, 2000?
Annexure 6.
2015, or which date you
Millard.
abandoned?
After completion of training, she has gone.
You have
And-
never joined thereafter.
Thereafter joined Kalani. And this order of disengagement was passed without affording her any reasonable opportunity for being heard, without considering and making disposal of representation, and she being served by this order of disengagement made an appeal before higher authority ventilating her grievance before the appeal number 1 saying this is my grievance, it may kindly be considered and looked into.
When you made,
And that representation is that,
Listen.
yes,
when you made that first grievance?
yes, that grievance, yes, your 12/1/21. 12/1/21.
Grievance itself is made on 12/1/21.
That is,
Since 2015, though you were appointed as what?
Millard, that is, this representation is after this order of disengagement.
Your initial appointment was what?
As what?
Shiksha Sahayak.
Dikha Sahayak.
What should children do? If you do not go because you have to look after your husband and children, what the children in the school do?
These are the facts, Millard. But my difficulties with she faced it.
What's difficulty? Whether husband would have shortened it?
Millard,
She should have said, I have been appointed, Abhi, I am going there. I have made a representation to post me nearby your house only. Once they take an order, I will come to your house. Which prevented you from what the children should do?
this is in fact the situation which has happened because of her difficulties which she faced and which prevented her from attending her schools after completion
What
of
did
training.
Your major.
Only 130 kilometers. 100 kilometers.
Within the
30
same
kilometers.
district.
From Mohana block, she was to go to an interior place 15 kilometers. There is no communication of her going, particularly but in that Gajpati days, these are the inconvenience of communication. So, what has happened? The order of disengagement before being passed, the opposite party, the respondent number 3, ought to have given her an opportunity of a hearing, which was not done because the source of livelihood which was being taken away by the order of
Where is it taken away?
disengagement.
You are not work data.
That is a fact which I cannot improve because this is the fact before Lordship. I am fairly submitting. This is the situation. Admittedly, the order
What your husband is doing?
husband was serving as
Also
an
teacher.
art teacher. Now,
You look after, you have looked after all these things. Where is the question of livelihood?
Millard, she having been selected and appointed and having been sent for training after
That's
completion
all.
of training.
We are asking a question based upon your submission. You said it's a question of means of livelihood. Means is our word. To put the English correctly, we are saying, you are saying that this is a question of means of livelihood. Where your husband is employed.
That is true. She becomes a dependent on the husband.
Therefore, you can't say the livelihood. You should have moved a petition under where have you said? The husband said that we will not give you money unless you work and bring the money.
Two aspects I am highlighting before Lordship. One,
There is nothing.
no person can be condemned on a higher. No person can be condemned on a higher. This is the settled principle of law.
But you went.
But the action,
you
and
went
actions
without saying anything.
and actions involving civil consequences are to be taken with due observance of principle of natural justice. When the order of disengagement on Annexure 6 is being passed by the opposite party number 3 against appellant,
What do you say, Mr. Manti?
No true dates.
Miller,
Any other point you have?
no,
One is livelihood, another is opportunity of hearing.
this order was called in question before this honorable court, and the honorable single judge at the stage of admission without issuing notice at the
Why he
statement.
should issue notice? Suppose if your suit is bad, limitation, still he should issue notice to the other side.
Miller,
We'll say limitation is bad.
Miller, the ground and which your lordship had, the honorable single judge had dismissed the case, your lordship may kindly.
That ground is available to them.
Yes.
If it is allowed, Mr. Monti has taken that ground. We have not been heard in the matter, no opportunity. Therefore, remand it. Then we have interfered also. But for petitioner, he cannot take up that ground. In every case, we should issue notice. Why? You not issue notice. A prima facie case, see, your conduct, you are appointed not at FDC or SDC. You are appointed as a teacher. Is it not? It is under teacher-student ratio. Your appointment would be considered. You never bothered about the children at all. You bothered more about the husband than the children. Where should the children go without a teacher? No.
Because
not
your lordship is right in saying this is one aspect of the case. But the circumstance, your lordship can see
Yes.
the input order against the way the writ appeal is filed.
Opportunity of hearing. Number 2, means of livelihood. Third is difficulty in leaving the matrimonial. Yes, please.
And the order of, the order of Honorable Single Judge, the ground.
There is nothing. Yes.
15 million, it's a state appeal, but it is in the list of weekly list in 39 by mention. So it may be for next week.
Yes.
It was in the list in the next week.
Yeah. Next one.
Item 16.
On request of the AGA, finally. Yes. Yes, sir. Yes.
This intercourt appeal, there is delay of 368 days, my lord.
368 days.
My lords, not so far as the merit is concerned, my lord.
What is the explanation for 368 days?
For 368 days, my lord, the appellant's health ground has been taken as
What
ground.
was the health ground? What was he suffering from? Where did he take medicine?
My lord, he has only stated that he has some cardiac problems. And besides that, my lord, earlier this writ appeal was filed by the president of the managing committee, my lord. And that writ appeal, the defects could not be removed as because the president expired in the meantime. But thereafter, the present petitioner, who is the secretary of the managing committee, has approached this Hon'Ble Court by filing petition for leave to appeal, my lord. And that's why the delay occurred. Although this has not been stated in the
Whatever is stated, otherwise you have to enter your witness box, we'll cross-examine you. Yes.
Only in
Whatever you have stated in your application,
application
to
for
that you have to confine. If you say one word extra, then you have to enter the witness box, give an opportunity to
what I
cross-examine.
submitted letter, my lord, that I have stated
Where
in the
is
appeal memo, my lord.
Where is that?
That page 9, my lord.
Show that you
The
are
appeal
explaining.
memo that I have stated, paragraph 9, page 9, my lord, that it is pertinent to mention here that previously the president of the managing committee of the school,
Where are you reading?
page 9, paragraph
Where in your,
from the
in your application?
in the application, my lord, this ground has not been inadvertently taken, my lord, only have taken the health ground. I bow down, my lord. So in the appeal memo, I although have stated,
Slowly.
my lord,
The president of It was dismissed on which date? When he died? When the president died?
my lord, so during my lord, that it was fixed for my lord. It was fixed for removal default to 12/6, my lord. Failure within 12/6/2024, my lord. If the defects are not removed within
That's all right. We believe you. When the president died?
before 12/6/2024,
It has to be. Don't say that. You have to tell the date.
date has not been specifically.
Then, for the impute order is dated
But improved order is dated, my lord.
18-3.
18/3/2024, my lord.
18/3/24.
My lords.
You filed WP writ appeal on
The writ appeal on present writ appeal, my lord, on
27-4.
21/4/2025, my lord.
when the president died. That you have to give. That's the essential fact. Then we cannot do that. Suppose if some poor man is coming, we can understand. Say managing committee of a high school, and vocational high school.
But so far as the merit is concerned, my lord, the interpretation of a particular provision of statute is under consideration, my lord.
Yeah.
So, my lord, section 10 of A of the Orissa Education Act, my lord. So the Honorable Single Judge dismissed the writ petition filed by the President of the Managing Committee on the ground that prior to termination of that incumbent, my lord, the permission of the Inspector of Schools, now the District Education Officer, has not been taken in view of the provisions of section 10A. My lord, my response concern before your lordship is that, my lord, that person was appointed beyond the yardstick. So there is
Beyond
one yardstick, my lord, admissibility of the post, my lord.
Not yardstick.
Yardstick, my lord. But as per the
Was he
yardstick,
appointed or not?
he was appointed, my lord.
1 second. When was he appointed?
My lord. He was appointed
94.
in 94, my lord. I'm
You
giving the
are
date.
putting the date here.
27/6/94.
My lord.
27/6,
Again.
1994.
1994, my lord. 27/6/1994 plus 24.
Night watchman come.
27th night watchman.
Night watchman.
Sweeper.
Here, my lord, there is one post available.
All right.
And-
And watchman he is.
But here, one person has already been appointed in 1991. It is appointed.
Some teacher or something like that. The poor people. You are an institution.
So post is one, my lord. The post is one. One person
That makes no sense. 27/6/94 he was appointed.
appointed.
When you removed him?
My lord, we removed him, my lord. We should so we removed him, my lord. By the managing committee resolution dated 2009, my lord.
23/10.
2009.
So you realized after how many years? Is the appointment is
He was terminated on the ground that his unauthorized absence, my lord.
Huh?
He was terminated on the ground of his unauthorized absence, my lord.
For termination condition is you have to take permission of XYZ officer.
My lord, officer, my lord. But here only question for consideration, my lord. This field is gray area. It has not been decided whether permission is required for an employee who has been appointed against a non-existent post. There is no post, but there is one post of.
We'll say if you appoint, the vinculum juris of employer-employee begins. That appointment may be bad, but not void because you have acted upon. You have made appointment. Can you say, no, we have wrongly made appointment? Government, because it functions with, does its job.
The then managing committee, my lord, in the year 1994. The then managing committee had appointed, my lord.
You see, there is always
Successive-
continuity of management.
My lord, successive.
Successive parties.
That I
But
was.
why you take action against those who are now out of the managing committee for making this appointment? It's a poor fellow. You have proved a delay of how many? More than a year?
368 days, my lord.
368 days. That's the only point.
That's the only one.
Then learned single judge have rightly said. Learned single judge have rightly said that any termination of appointment needs prior permission of XYZ officer. It does not depend upon the appointment being not done in accordance with law. That is not the question.
That is my.
Anyway, did you tell the authority like that? He was wrongly appointed and therefore there is no need for taking permission.
No, my lord.
If at all.
That is not there, my lord. So here, my lord, that point has not been decided. What the
We are deciding.
my lord?
We are
It's not
deciding.
in-
Means of an educational institution is directed against order dated. The series that I don't know.
My lord.
18/3/2024.
18/3/2024, whereby the poor respondent employees WPC number 10386 of 2010 having been favored.
No, my lord, no. The WPC was filed by
No,
the
by the
president, challenging the honorable honor tribunal.
One second. Filed by the petition, filed by the appellant
Managing committee.
has been negative. First time. In the said petition, the challenge was laid to the order dated 27/4/2010 made by the State Education Tribunal in appeal case number 43 of 2009. First time, the tribunal had held that the termination of the respondent from service was bad for want of compliance of the provisions of Section 10 capital A of Odisha Education Act 1969. 69. First one. Next paragraph. Learned counsel appearing for the management, appellant management, vehemently argues that the respondent employee was appointed in gross violation of the normative procedure, semicolon. In view of that, there was no vinculum juris of employer-employee, semicolon. Therefore, taking the prior permission of the designated authority is not necessary. That's your argument. And visit it. First off, this having not been duly considered by the learned single judge, it tells us, there is warrant for the interference of this board in its appellate jurisdiction. First off, Mr. Manti, you support the order or
Support.
learned DCA, Mr. Manti, on request appearing for the official respondents, resists the appeal, making submission in justification of the reasoning of the learned single judge on which the improved order has been constructed. First, next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter on the following grounds. Number one, the impugned order was made on 18/3/2024. Semicolon. The appeal memo has been presented to the registry on 21/4/2025. There has been a long delay of 368 days brooked in filing the appeal. First off, an application in I number so and so supported by affidavit has been moved along with the appeal memo seeking condonation of the said delay. First off, learned counsel for the appellant vehemently argues that the delay in filing the appeal was due to death of the then president of the managing committee. First off, however, not even a whisper is made as to when the said death occurred. And in the absence of precedent, why others could not manage to prepare appeal in time. First off, the explanation offered for the long delay is not plausible. First off, therefore, application is liable to be rejected. Next paragraph. The second submission of learned counsel for the management that once the appointment of an employee is contrary to the normative prescription, that would not bring into existence the employer-employee relationship, is very difficult to obtain. First off, firstly, the appointment of the respondent was not to any pivotal post, but to the post of peon cum sweeper.
Night watchman.
Night watchman cum sweeper by the order dated
4/11/91.
4/11/1994.
27/6/1994.
27/6/1994. First off, the termination has been done with effect from 23/10/2009. First off, therefore, at that length of time, whatever arguable irregularities had infected the entry point in service, would wither away in the kiln of time. In the kiln of time, kiln of time. First off, the added contention that the appointment was made by the predecessor management members would not take case of the appellant even 1 millimeter forward, there being established the principle of rule of successive continuance. in the management with any judgment. Yes, stop. One judgment of the matter. In the above circumstances, therefore, any termination from employment has to be preceded by the prior permission, preceded by the prior permission granted, secured at the hands of competent authority, as has been rightly observed by the learned single judge. First off, no rule nor ruling to the contrary is cited before us. First off, in the above circumstance, both on the ground of delay and on merits, the appeal is liable to be rejected, and accordingly it is. Have you complied with the order of the learned single judge?
My lord, that instruction I have to do.
The appellant to comply with the order of the learned single judge on a war footing and report compliance to the Registrar General of this court within an outer limit of 4 weeks, failing which the respondent may move an application for punishing the members of the management for contempt or otherwise. Registry to send a copy.
You know, respondent number 4. Respondent number 4 was the appellant before the learned tribunal. Respondent number 4.
Respondent 4 was the that is employee.
No, that's the employee.
The employee.
Okay, accordingly. Yes, sir.
Item 17.
My lord, item 17,
Yes, sir.
the state appeal having a delay of 658 days.
What is the explanation
I-
for the delay? Who is the respondent?
Here, my lord, respondent is the other side.
Is what is the status?
Builder. I pray for a week time because it's a matter needs a thorough preparation.
He wants to prepare. We always
Because it's a 2020.
call week of the next at the request of learned DGA, who assures of higher level of preparation first on of the case. Okay. Finally. Yes.
Item 18.
Yes.
Item 18 is 42 of the today's list meaning.
42. We'll take together.
Some of the matters are being listed possibly on mention because it is in the weekly list once again. So next week, no.
Next week. Okay. Next week along with 42. In 42, who appears? 42, anybody present before the court for respondent?
No. 42 is the same matter, which is in the board in the weekly. Once again, it is being listed today.
It is duplicated in 2 days. Let's see that. 21. Week after next at the request of so and so finally. Yes.
Item 19.
Yes, sir.
19, my lord, it's a state appeal. Here, my lord, challenging.
494 days.
It is a delay of 368.
368 days. What is the matter?
This is in respect of regularization of the 100 teachers, those who have been appointed on contractual basis.
Appointed on which date?
It is they have been appointed on 11/1/2010 million.
Was there advertisement?
Yes, ma'am. This is for a purpose of
Advertisement is dated what?
there is no advertisement.
No advertisement.
This is for a
promoting 100.
promoting one language of the tribal community in 5 districts. They have been appointed, madam, by virtue.
No advertisement. Are you sure?
Yes, ma'am.
When making appointment of 100 people, there is no
In
advertisement.
different 5 districts.
That's all right. But you appear, brother, you appear for respondent. You appear for respondent. Was there any advertisement? What are you doing? You could have turned the pages sitting here itself. It's an opportunity for you to argue. And you can pass on the blame on the judge, saying that judges were very unkind and they did not give time.
And subsequently, my lord, by taking the cabinet decision in the year 2021 as a one-time measures,
Dated
dated, my lord, 22/3/2021.
cabinet decision
Yes, ma'am.
to continue.
To continue, and they have also been given the benefit, my lord, regularized.
Regulation is given.
Yes, ma'am.
No, what was their complaint?
Their complaint is, so far this Honorable Single Judge is, my lord, from the date of appointment, that is in 2010, my lord.
2010.
In fact, there,
That is 11/1/2010, date of entry.
exactly.
Why is that reason? What the reason Lord Single Judge has given?
It is at page 19, my lord, for me.
Paragraph?
This is at paragraph.
Which para? Reasoning part.
Para 6 mil. Para 6.1. 6, it starts from 6 mil. Page 24.
Whether a tribunal had directed the regularization of service.
Yes, for consideration, that I have quoted.
Where is that? Well,
This has been
there was
quoted.
the direction to regularize itself.
Yes, sir.
Whether for consideration
Those
or
who have-
regularization.
Those who have completed 6 years.
For consideration or
Consideration for
For consideration.
consideration.
Yes.
Read the order of the tribunal. See, after facing regular process of selection, you said there was no advertisement at all. May not be. You may not be correct. Just verify. Your senior is held up in other.
My lord, Corpan 3, it has been quoted at page 20. We have taken the stance in the, before the tribunal in the counter. The GA department notification dated 7/9/2013, the service of the contractual employees and completion of 6 years of service to be regularized. But the
There is a
applicant,
direction to regularize. There is a direction, not for consideration. Because they had completed 6 years during the pendency of that OA. The
OA.
OA it is here.
Wait. But at one time, the cabinet has taken a decision, and accordingly they have been.
That's all right. But question is, there is an order of the court.
Yes.
The tribunal in SP Sampath Kumar and in L. Chandra
L. Chandragum.
Kumar, appellate court said it is a substitute for the High Court. So it was a High Court decision. Where is the error in this judgment? If cabinet takes some decision contrary to the High Court judgment,
Now we have taken a decision to regularize them.
regularize with effect from which day?
Effect from the date 23/3/2021.
That's right.
As a one-time measures.
That's wrong. Because tribunal order was staring at you. You are not challenging the order of the tribunal. Not challenged.
Not challenge, but dismissed.
This is challenge, but
Challenged also. Then what else? What remains for you? WP number?
WPC 14761 of 2018. It is further challenging the order passed by the tribunal on 10/3/2017. State approached this court on WPC number 14761.
That they have not.
18. But this court had order dated 24/1/19 dismissed it
dismiss the bit.
while confirming the order of the tribunal.
So then what? What remains for you? What business cabinet has to sit in appeal over the court, High Court?
Because it is a financial matter, 100
You should have
teachers are
filed the appeal
there.
against that order.
We have taken the risk that there should be regularized because for the development of the particular language in 6 districts.
All that could have been the ground if you wanted to challenge. You can't upset an order of the. It is an affront to the court. It is an affront to the court. It is a kind of contempt to the court. Well, we are not saying we are superior to them, nor we agree that they are superior to us. We operate within our
Yeah,
space.
they have
operate within their
taken up
space.
the issues. They have taken up the issues as a one-time measures.
Do you want to say anything?
Nothing, madam.
Yes, very good. Whether there was
Advertisement,
date of advertisement.
2010. Advertisement 2010. After your order issued.
Date of advertisement.
Because in your notes, you have said there was a due process of selection.
They have not reviewed copy. They have to copy and confirm the copy not so, sir. But that is not disputed. After advertisement selection, collector passed the order appointment. That.
They were appointed as what?
Are the language teacher, madam, in tribal schools.
Language teacher.
On a contractual
Tribal school.
contractual basis. Madam, tribal schools. Where all tribal teachers, madam.
And they are getting a consolidated amount of 3050 million.
Contractual amount.
Which has been subsequently enhanced. And now they are getting 23.
No case for you. The respondents having undergone a due selection process were appointed as tribal language teachers on contract basis with effect from 11 January 2010. First off, Mr. Mohanty, learned AGA, tells us that they were given a consolidated pay of rupees 3050 per month. First off.
3080.
3050.
5080.
No, 50.
They were ventilating their grievance in OA number 404C of 2015 for against non-regularization of their service in terms of which is that
That notification is 17/9/2013, my lord.
resolution or modification?
This is a resolution, department resolution. Those who have completed 6 years.
Department resolution dated
17/9.
Department resolution dated
17/9/2013.
13, which provided for such regularization after completion of
6.
a continuous service of 6 years with non-blemish. First one. The tribunal, the state administrative tribunal, wide order dated 10/3/2017 directed their regularization with effect from the date they had completed such a period of service.
6 years.
First one. Next paragraph. Learned counsel appearing for the respondent employees tells us that the above order of the tribunal was put in challenge in WPC 14761 of 2018
madam.
by the state, by the appellants herein, and the challenge was negatived by a coordinate bench of this court wide order dated
24
January
January
2019. First now. Therefore, the learned single judge, first, despite this, the appellants took a decision based on a cabinet decision dated
22/3/2021.
22/3/2021, whereby the regularization was in effect, was made effective from the date of that decision. First off, in other words, the regularization which the appellants ought to have granted to the respondents with effect from the date they completed 6 years of service, pursuant to the order of the administrative tribunal, stood postponed by about 8 years. 8 years. Is it not? Yes. By about 8 years.
6 years.
6 years.
Six
Six
years.
years.
Six years. Sorry, 6 years.
5 years to 6 years in between.
You are right. 6
years.
years. 6 years. First up. This learned single judge in respondents WPC number 10372 of 2022 altered and granted relief consistent with the order of the tribunal. First up. Next paragraph. With the above backdrop, the present appeal has been preferred against the against the order of the said order of the learned single judge. Put that sentence there. In this paragraph. Same paragraph. Next paragraph. Learned AGA Mr. Mohanty vehemently argues that the appointment itself was contractual and therefore the respondents could not claim the benefit of regularization with effect from the day on which they completed 6 years of service. More particularly in the teeth of cabinet decision, D capital. First of all, this is very difficult to countenance. And reasons for this are not far to see. Firstly, the policy decision of the government provided for 6 years, that is known. As expressed in the GA department decision, GA department notification dated 17/9/2013 had provided for regularization immediately after the completion of 6-year continuous service. Record from the date of entry. First off, admittedly, the respondents had completed 6-year service way back in 2016. First off, they had also fought a legal battle on the floor of the tribunal successfully. And the tribunal direct-wide order dated so and so had directed as under. Tribunal's order is
10/3/17.
Wide order dated 10/3/2017 had directed as under. You will produce that.
Annex 5.
Next point. Secondly, we can make it to add to the above, secondly, this order of the tribunal was unsuccessfully challenged by the appellants in writ appeal number WPC number 14761 of 2018, which was negatived by the coordinate bench wide order dated 24 January 2019. 2009. First time. No further challenge was laid before the apex court. First time. Thus, the matter has attained finality. First time. That being the position, it is ununderstandable as to how the cabinet could take a decision on
22 March
2021 to postpone the benefit of regularization by 6 years. First off, it is absolutely unjustified looking to the order of the tribunal that had attained, that had secured imprimatur of the coordinate bench in a challenge mounted by the appellants in WPC 14761 of 2018, dismissed on 24/1/2019. First off, the decision of the cabinet is nothing short of an affront to the judicial process.
May I say?
Yes.
One.
Yes.
Initially, the appointment was Integrated Tribal Development Agency.
Yes.
Subsequent,
ITD.
ITD.
Thereafter, tribal language.
Like, thereafter, subsequently, by virtue of this cabinet decision, they have taken into service with all regulation.
That's the makes Okay. In the above circumstances, this appeal is liable to be dismissed with an exemplary cost of rupees. Yes, because cabinet took a position affront to the High Court.
My humble submission.
Yeah.
As it has been appointed by the ITDA for the development of that language school in 6 districts, subsequently keeping in view their continuance and the 2013, cabinet has taken as a one-time measures. Purpose.
Or not complaining.
The order of the
They are getting all the benefits as of now.
The order of the learned single judge shall be complied with within an outer limit of 6 weeks. And compliance report be filed with the Registrar General of this court within 1 week next following, failing which it is open to the respondents to move an appropriate application before this court for levying heavy costs on the erring employees, erring officials of the state government.
May I pray for
To move
3
application.
may I pray for 3 months because 7 district, my lord.
But
We have only one district.
They are getting the benefit. All the benefits. Existing benefits are there.
3 months. 3 months. No issue. Anyway, it will come before the same bench, na? That's really. After
No, it will
3
be
months,
done, my lord. It will be done. Because they are existing employees, they are getting all the benefits. These are the
Other parts.
Exactly. That remaining residual part.
And for that also the single judge has asked for 50%.
50%.
50%. Exactly.
50%.
you did not file appeal. Not anyway.
We approve them, but
See,
Well, government has taken a lenient view for them.
what lenient is our single judge has taken the lenient. Yeah.
Item 20.
Now, one sentence you should add. We have also noted the lenient view taken by the learned single judge in awarding 50% of the benefits, comma, when arguably the respondents were entitled to 100%. Somewhere you just insert that sentence. Yeah.
Item 20.
My lords,
Yes, next.
state appeal,
Yes.
impugned order is at page 29.
No, just make a statement.
My lords,
Just what was the complaint before the learned single judge?
my lords, my lords kindly see it is 4 paras only.
Order itself is 4 paragraphs.
My lord. And the learned single judge has recorded that the state doesn't dispute the
No difference between full grant school and block grant school.
well.
Yeah.
But here he claims benefits. And the judgment relied on was relating to applicability of rehabilitation assistance rule. My lord. That I have annexed in the next page 32.
No. Only consideration.
My lord, that is what.
Still you want to challenge the appeal?
No, my lord, sir. That
The appeal
is,
is maintainable against direction for consideration.
my lord, sir.
Unless the parameters are fixed and you have no.
My lord, it is not. That is why I brought to your lordship notice.
This intra-court appeal by the state and its functionaries seeks to call in question a learned single judge's order dated 11/5/2000, judgment dated 11/5/2016, whereby entered in respondents WPC number 5022 of 2013, whereby a direction has been, the matter having been remitted to the jurisdictional authority comma, a direction has been issued for consideration afresh within a period of
My lords, case number
the case of
12888, my lords.
consider the claim of the respondent within a stipulated period of 3 months. First up. Next paragraph. Learned counsel AGA, Mr. Behura, vehemently argues that the order of the kind could not have been entered in the fact matrix of the case, and therefore indulgence of this court is eminently warranted. First up, we do not agree. First up, we say that we do not agree because the direction is for consideration. With the parameters as have been delineated in the body of the judgment. More particularly, paragraphs 7 and 8, which read as under. First one, in the above circumstances, the appeal being thoroughly devoid of merits is liable to be rejected in limine. Anybody is appealing for the institution?
No, my lords. No, my lords.
And
Limitation.
accordingly, it is.
My lords, delay is there. Your lord.
And limitation? The above apart,
Delay
the
of
appeal has been preferred after brooking a long delay of
377 days.
377 days, and the explanation offered therefore is not found to be plausible. First off, day in and day out, we have been observing appeals being filed after brooking enormous delay with no plausible explanation at all. First off, this is one such case, one more such case. Okay, you put another this one. But therefore, we do not agree with the prayer made in the application. Yeah.
My lords, the case number was wrongly. It is WPC number 12888 of 2024.
Okay. 5022 you have given.
My lords, page 29, the impugned. The lordship said 502.
Single judge order.
Yes. Only in
19624.
my lords, 12888 of 2000.
12888 of 2024.
My lords.
Then the reading begins. 1962024. Huh?
Well, only that.
24, whereby the respondents, the WPs, the challenge is to order it in 19/6/2024 entered by the learned single judge of this court, whereby respondents WPC 12888 of 2024 having been disposed of with a direction to consider its claim in
terms
the
of
light of Ratananjali Giri.
Gitanjali.
Giri, Elias Paul versus State of Orissa, 2016, 1 ILR 1162, within a period of 3 months. First time. Okay. Next paragraph. Mr. So-and-so argued like this. We do not agree because direction is to consider.
Yeah.
All parameters having been kept up.
My lords.
That's all. Only that comes. Rest of the strike. And other paragraphs is strike out. Appeal being thoroughly devoid of merits is yes. Next.
Item
My
21.
lords, item 21, 22.
Have you
brief-
what period? What period you will comply with this order? The appellants will comply
8
with
weeks,
the order of the learned single judge
8 weeks.
within an outer limit of 8 weeks, and the compliance report shall be filed with the Registrar General of this court within 1 week next following, failing which it is open to the respondent to move an application, appropriate application for taking penal action.
It's item 21, 22.
21.
Actually, briefs are not.
21, 22 I am appealing, man.
Huh.
This is covered matter, my lord, your lordship.
Brief is not with
That's
because
it,
of.
With you.
Relying that that's something judgment.
Okay, next week.
Your lordship judgment.
Next week we'll do that. Next week we'll do that.
One-
Same we have followed
Yes,
another matter
the-
today only.
Yes.
My lords, in fact, I have not
Call next week.
possessing.
Next week. At the request of. Yes.
Item 23.
May I please?
Yes, sir.
Matters, I humbly submit for matters kind appreciation that the delay is due to wrong
How
advice.
many days?
558 days.
589 days. What?
558 days.
515.
Well, due to wrong advice and approaching wrong forum. That is the only thing.
Wrong advice. Which lawyer gave wrong advice when? What was that wrong advice?
And approaching wrong forum. And one more thing, my lords, if my lords will be inclined and be pleased to condone the order condonation of delay, there will be no prejudice caused to any citizen because this district sub-registrar is the opposite party who has refused, endorsed refusement of registration of a cancellation, deed of cancellation of a registered joint venture agreement. The learned single judge, with great respect, has erroneously held that a joint venture agreement is a deed of conveyance which requires registration under section 17, which is not correct. That is a simple question of law and a very important question of law also to be adjudicated by a law
Section 17
of the Registration Act.
enlists what
Yes.
is the
Yes,
compulsory
minors.
registrable document.
Minors.
Who will tell?
Yes, it did. I'm sorry.
Kindly listen
I'm
to
sorry.
us. Kindly listen to us.
Pardon, ma'am?
Kindly hear us. Hear our argument.
Ma'am.
Yes.
So,
But you will not pass the order.
well, section 17.
One second. Section 17(1) gives a list of documents,
Yes.
not
Oh,
transactions,
I am obliged, deeply obliged.
which require compulsory registration.
Absolutely, madam. Absolutely.
Second one. Section
22A.
22 capital A.
A of Orissa Amendment
Orissa Amendment.
Pro- provides which documents shall be refused to be registered.
Okay.
And under these two, the appellant's case doesn't come. It's a mere agreement to.
1 second. That 22A, your
Yeah.
Orissa Amendment,
Yes.
is it exhaustive in nature? All other documents must be registered.
No, 22 is a which document?
Therefore,
Optional. There are optionals. Certain documents, that is section 17 again will come.
17, 18 optional
Yes,
documents.
yes. Then 22A says which documents are to be refused to be registered. So under these two
We
categories.
are asking you
Yes, ma'am.
whether the documents enlisted
Yes.
in Orissa Amendment,
Minors.
whether they are the exhaustive document. Beyond that, there is no other document.
They're
That
They have given that list. May I place that?
how courts have, this court, various judges of this court have taken the view.
They view that deed of agreement. May I kindly appreciate.
Shall refuse to register. Your document fits into which category?
Minors.
Your document
Fits into which category?
Your document fits into which category?
It comes under section 22A.
Which one? There are many documents.
The document is a joint venture agreement, that is Annex 1. A joint venture agreement, short background of the case.
We have understood, in fact. Therefore, we are
So
asking you further
it's an agreement where there is a specific clause, my lord, that in the event the other party fails to comply his terms and conditions unequivocally undertaken in the joint venture agreement, there shall be a notice of 2 months written notice to the other party failing to adhere to the conditions, and the joint venture agreement stand cancelled is already stood cancelled. Already stood cancelled. That process is already over. It's only because it's a registered document that has to be cancelled, because unless my lords may kindly appreciate, unless it
Otherwise, you cannot transact with the property.
property is vast, 150 crores property, and the development agreement he has signed, trade away, non-responsive, and doesn't come. And now the property is lying because no other
It is for
vendor is
admission
coming.
now. First time it has come. You take notice. Very, very important question. Very interesting question also.
Well, it's,
Well, they have already.
Two things. He says 17(1) is not invocable because no interest is created as such. Number two, it is not one of the enlisted documents under the state amendment 22A. Therefore, question arises whether, except those which have been enlisted under 22A, other documents can be refused to be registered or not is the question.
in fact, the single judge, Honorable single judge has allowed the writ petition.
Allowed the writ petition directly to the district office. I'm ungrateful to my friend.
You are in appeal.
No,
We are
Why you are in appeal?
Well, we are in appeal because Lorraine single judge ordered directed the district sub registrar to register to consider to register, and
He should have straightway directed cancellation.
consider to register. Once again, it is presented, and when it is presented, he considered as if he is the
And rejected.
apex court judge, give a judgment where, when my lords know, already Supreme Court has already said that the registering officer has no adjudicating power, except that he will find out with procedural irregularities or regularities whether the tax has
You
been.
take notice.
Yeah,
Any
they have
other
already-
private party?
Well, it's private.
No, my lord.
No.
In fact, it is a JV. As per the Partnership Act, should be.
Private party.
He should have been made a party.
No,
Other-
private
No,
party is there.
No, private party you have to make.
Well, she has not been made party because I will satisfy Lordship that despite repeated approaches, despite repeated communications, he did not respond. Oh,
That we have to assert. That is your version.
yes,
Should not the court ascertain that?
yes.
You will direct you instead of filing application. We direct you to implead him. You impleed him now.
My lord, in fact, in the writ petition, he was not
Not a
added.
party anyway. But we can give this one.
So,
The-
so
The appellant is directed to array the party to the JV in joint venture agreement in question as respondent number 3 to this appeal.
that's one.
First up, learned counsel on record with leave of the court has amended the cost table. First up, issue emergent notice to the newly added respondent.
I will file it.
Delay, then our service we can
Yes.
delay. We will after service we can.
One minute, maybe pardon my lord. I will make amendment of the cost title and file it. Make amendment to file it.
Sir, just correct.
That is in there.
Because pursuant to order, our
And
order.
thereafter, notice automatically, I will send the notice. My lords may kindly order that notice will be taken by the appellant.
Appellant to take notice. After filing of.
Appellant to the respondent number 3, newly added party respondent 1.
I pardon my lord.
Oblige, my lord.
This act, my lord. Bank issued person notice, my lord. Naturally, ready for listing, my lord. Monday, my lord.
Monday. When notice is under 13(2) or 14 notice?
13, 14, by the 13, 4, my lord.
Possession notice.
Possession notice.
When, which date they have seen?
They have issued it 15, my lord. 15 to my lord.
52.
I have already packed.
Tuesday we will take.
File is ready, my lord.
Tuesday.
I will pattern matter.
Yes,
Item 55 in the weekly list.
55.
May I pay that it was listed in the supplementary on 23rd?
What is the specialty?
No specialty.
Except that you are saying, then we will not take.
Well, in item 23, I will file
My
the
lord.
Yes, sir.
amendment here.
Yes, yes.
Here only. Okay.
One thing, my lord, the land has been acquired by the MCL and the compensation has been deposited. So unless the matter is taken up and some interim audit is passed,
You can't take the money.
yes, he may the other side
Shift into daily list.
Objection. 19. 19. Mr. Nanda has served a copy on me. The lordship may take it after a week or so.
What is that? Contempt?
No, my lord. It's a modification of the recall of your lordship's order.
Week after next. You inform the other side also.
No, he is there.
Yes.
Pardon to mention, my lord.
Yes.
Pardon to mention, my lord. Item 71, 72, 73. All three matters are relating to another matter. Those matters are listed to 13th March, my lord. Those matters may be taken up along with those matters.
70?
71, 72, 73. I'm for the, yes, madam.
It's contempt.
My lord, advocate for the petitioner is also there.
You are for whom?
My lord, I am for the contempt, my lord.
Contender.
Similar.
No. Yes. No question of we are here to punish the contenders. We are just searching for them. Yes.
Miller matters are there for the.
Whatever order we have print it there. We are here to. We are just searching for the contenders. Yes, with lantern and the battery torch. Yes.
Item number 63.
Contempt matter.
Contempt.
What is the
I am filing the show cause today. So your lordship may.
No. Next. We will not.
Item 1.
Whether that police officer is in connection with any contempt matter?
Yes, madam.
62.
Yes, madam. Personal appearance.
Personal appearance was sought for.
In fact, notice is to serve upon the party concerned. Somehow or other it could not be served.
Why it was not?
No, it was not communicated to the concerned police officer. They have taken the indulgence and served, and today it has been served also. This is the copy.
So last time it was not done.
Exactly. That could not be.
Offer explanation.
64 was 64.
Item 64.
I am in 64. Sorry. I am in
62 also there is a person.
Ask him to wait because let him wait. He has not done his duty. Let him wait. Yeah. First.
Item 1.
Non-compliance of order dated 2011-2025. Dr. Kindly see Annexure 1, page 6.
First time. Police notice. Emergency police notice. We have made a warning, etc. So, how many contemners?
One minute.
Yes. 33. Yes.
One, your lordship, disciplinary proceedings have been initiated against them.
In which?
In one, your lordship.
Serial number 1.
In, yes, your lordship, content number 485.
What was the order?
Lordship, paragraph 3, my lord, page 6. Learned AJ Mr. Bauda on request appearing for the opposite parties opposed the petition contending that the petitioner is involved in POXO case, which is serious, is that he having misbehaved with a girl student.
Number 2.
It is not
the request of lower options for issuing clarification as to what should be done in the matter in a time-bound way. It needs to be done within a period of 4 weeks. You have initiated. Prior to
that, a disciplinary proceeding has been initiated against the petitioner.
2026. Your lordship.
Even
2026, your lordship.
26.
Yes, your lordship. This is a communication that we've received from the officials.
Initiated by order dated 31/1/2026.
Yes, your lordship.
He was arrested and detained on 23/9/2020. You are the complainant. You are the victim from the side of victim girl.
No, my lord. I am for the petitioner, my lord.
Petitioner means
against whom complaint has been made.
Yeah, no, disciplinary inquiry is initiated.
Here, my lord, my claim is to allow me to discharge the duty after my termination order has been quashed.
What was the order passed?
First, my termination order has been quashed by this Honorable Court, which has been confirmed by the Honorable Supreme Court also. And where Honorable Supreme Court has directed to if any disciplinary proceeding may be initiated, my lord. Thereafter, they did not allow me to discharge my duty, my lord, after passing of termination order.
No, we did not agree because even if you are given duty, there are other girls. So your client will go on doing this one with all other girls. Therefore, we asked them what action they want to take up. You have kept him under suspension.
Yes, Your Lordship.
You have kept him under suspension.
Yes, yes.
The complaint alleges non-compliance of.
Not suspended. They did not allow.
That is not the order. Where is the order?
Only two.
The compliance, non-compliance of the order dated 20/11/2025 entered by this court in complainants WPC number 232376 of 2025. Rightly, they have put 376 numbers. Yeah. Next one. Paragraph 3 of the said order reads as under. Next paragraph. Learned AGA appearing for the has placed on record an order, a letter dated 31/1/2026. Which reads as under. Below that, one more sentence. It reflects that the disciplinary proceedings have been initiated against the contemner by memorandum number 114 dated 31/1/2026. First off, in the opinion of this court, there is substantial compliance of the order whose violation, whose non-compliance is common. First off. Next one, in the above circumstances, complaint proceedings are dropped with liberty to the petitioner complainant to work out any other left out remedy elsewhere in accordance with law. First off, in that connection, all contentions are kept open. Next.
Item 2.
May I please, my lord?
Yeah.
My lord. My lord, order dated 9/10/2025 for release of his increment during pendency of the department proceeding has not been complied with till then.
Serial number 2. Any information?
Your Lordship, I'll take it.
Reasonable within 10 days. Call this matter on so and so. Particular note, etc. Standard format. Yes.
Item 3.
Item 3, this one report on 19/12/2025 directed to Salgi posting in nearby college. They have passed the transfer order on 21/1/2026, which is 75 kilometer distance.
That you have to challenge elsewhere.
They had challenged, Your
I
Lordship,
have challenged
and they
the
withdrew it.
honorable court directed to file a representation. They will consider.
Item number 3 and 37.
Are same.
For the same purpose, the two content petition will.
By the same complainant.
This honorable court kindly recapture on the ground of sexual harassment. Your Lordship has taken the indulgence and granted that nearby you please wherever vacancy is there immediately you. Accordingly, this has been done. We are filing this compliance report. When this order has been passed, so far the transfer is concerned in person to the order. Now they have challenged this is the order, but my learned friend is submitting that has been withdrawn.
Honorable court directed
that we have complied, my lord.
They will consider. I have already handed out the tabs released from the college.
We have also e-filed, my lord. So far the 37 compliance is concerned.
Where is the complaint report?
37 e-filing each.
37, your lordship has issued notice. 37, item 37, we are the lady lecturers who have been sexually harassed by the principal. So your lordship has been pleased to issue notice. And request was not filed, yesterday it has been filed, that is item 37. Against the present.
Oh, even 37, they are saying they are compliant.
We have complied and passed there. My lord, I have e-filed and also hard copy.
What was the direction there?
Page 7, my lord. So far the nearby college transferring the person.
You are transferring to the
yes, that is the order dated.
That is 75.
Page 7, my lord.
It's a challenge before the court, right?
Exactly.
Not before this court.
And you have challenged it and then withdrawn.
This has also been challenged.
That is the order the lordship will.
So the honorable court directed to file a representation. The authority will.
If the lordship will call for the report prepared by the local complaint committee.
That is separate.
That is not separate thing.
Yes.
But I beg up. I beg up.
Is over.
I beg.
The court and the country. Will not be heard.
My lord.
Both the contact number 5588 of 2025 and contact number, so it's a common order. the Commissioner cum Secretary, Higher Education Department, Mr. Arvind Agarwal, has filed the compliance affidavit sworn to where is the swearing has taken place? Sworn affidavit.
Yes, ma'am. This is the original copy, ma'am. May I submit, ma'am?
Sworn to by him.
Definitely.
First, the affidavit is accompanied by the order dated 20. First, 20. What is that order? Annexure A1.
Yes.
Tell the date.
21st January.
21st January 2026.
Well, this is the original copy, ma'am.
Which relevant part of which reads as an.
They filed it.
Which reads as an, not relevant. Next paragraph. In the considered view of this court, there is compliance of the direction of, and therefore contempt proceedings are liable to be withdrawn. First off, accordingly they are. Next paragraph. If there is any grievance against the compliance order, it is open to the agreed to challenge the same elsewhere in accordance with law. First off, all contentions in that regard are over. Take this. Yes, next.
Item 4.
Plus one line plus one. Plus he has not handed over to charge. So the college partial handed over, fully not handed over. That part may kindly taken care of.
It is open to the complainant in contact number
Plus 532 of 2026.
27 to secure charge, complete charge from the complainant in the companion contact number 646 of 2026. Next.
Item 4.
Non-compliance of order dated 8/12/2025, my lord. The direction to the opposite
To
party.
make representation.
My lord.
You have made it.
Yes, my lord.
Where is proof of that?
I'm annexing annexure 2, my lord. That is the
Field post.
my lord. Endorsement also.
Yeah.
Annexure complete.
Same order. Next.
Item 5.
Item 5 is fresh content, compliance of order dated 18th of September 25.
Implement impugned order of tribunal within
8 weeks, my lord.
8 years. Yes. Same order.
Item 6.
Item 6. Non-compliance of order dated 8/12/2025.
Same order.
Release of dismissal, my lord.
Yes. Same order. Next time it will happen. Yes.
Item 7.
7 fresh contempt. Fresh contempt. Same order.
Item 8.
My lord, order dated 19/11/2025 has not been complied with.
Not complied.
No.
Same order.
Item 9.
Non-compliance of order dated 9/12/2025, my lord, wherein lordship director considered the representation within 6 weeks.
9/12.
My lord.
Will be 8, 12, 1.5 months.
My lord.
When it will be over?
I know.
12 weeks will be over when? It's a case you have filed advance contempt petition. Yeah.
Item 10.
Non-compliance of order dated 10/9/2025. 3 months time was granted to comply the order. The operating portion of the order, page 12.
Item 11.
11, compliance of order 16th of December 2025.
It has been
6 weeks, my lord. Because my disposed of on the basis of the Koras Malik. In Koras Malik, 6 weeks time was given.
Your Lordship, they have already passed a speaking order, Your Lordship.
The first order in challenges. What you have rejected?
Yes, please.
The complaint alleges non-compliance of this court's order dated 16/12/2025 entered in complainants WPC number 34850 of 2025. First, next paragraph. After service of notice, the contemners having entered appearance to the learned AG has filed with that order. Give this copy of the order. Order number 2619 dated 19/2/2026, whereby the direction has been complied with. First, this order has been made on the representation of the petitioner seeking appointment under the RA scheme in terms of RA rules 1990. First one, the claim has been rejected. First one, rejection is also a compliance. First one, next one, in the above circumstances, proceeding is dropped with liberty to the complainant to seek remedy against the said order if he is so advised. In that connection, all contentions are kept open. Put it in the file. Next.
Item 12.
That is Lordship order dated 23/9/2025. The Lordship granted 2 months time, Lord, 8 weeks time, Lord, to comply, Lord, regarding grant of pension and gratuity, Lord.
Yes, sir. What is any information? No. Yes.
Item 13.
In order dated 18/11/2025, your Lordship was the order of rejection and directed to give engagement to the petitioner, my Lord. But as yet, my Lord, no action has been taken, my Lord.
Item 14.
Document dated 16/9/2025. Page, my Lord. Page 14, NS1, my Lord. In the above circular, the petition is allowed a writ of session questioning the impending order dated 13/9/2024, NS 15, made by the Joint Director of Secondary Education, Odisha.
To appoint the petitioner in terms of blood clot scheme.
Yes, madam. Till to the not complying order, madam.
Same as. Yes.
Item 15.
May I please, your Lordship? I am on BC, my Lord. This Hon'Ble Court's order dated 5/1/2026 has not been complied by the opposite parties, that is the Vice Chancellor and the Registrar. Not complied.
Your claim is not continued.
No, they are not allowing me to enter inside the campus and they are not mobilizing this order, complying this Hon'Ble Court's order dated 5/1/2026 as an interim measure.
Item 16.
I am filing a modification application. Order passed dated on dated 14/10/2025. There is a related to one Ananta Narayan Naik.
Ananta Kumar Naik versus Registrar, Utkal University. No, that is not the case.
Not the case.
Which case it is?
It is the order passed by this Hon'Ble Court. Tulniwala Patti versus State of Orissa.
Who appears for the other side?
I am for the university. The copy of the IMP.
A copy is not given.
Well,
You served on a of the two. Yes. To have say of the respondents. Yes.
Item 17.
Item 17, my Lord, on behalf of the cases, I have to prepare for next week, my Lord, personal difficulty.
What is the order? Not that's you are not taken.
On behalf of cases, I will prepare for next week.
That is taken this one. Right. It's not already taken. Yes.
Item 18.
I have filed a IA for modification. Now I want to not press my God. IA 18509.
IA number
18509 flag A.
Is this code of as having not been placed. Yes, next.
Item 19 has been adjourned. Item 20.
My lord, item 20. My lords, in view of the development, I prefer 3 weeks time to comply, my lords. Because, my lords, the SLP dismissed on 16th February. Now we are taking steps for compliance, my lord. Only 3 weeks. Only 3 weeks.
Will record his submission.
Yes.
In the event they do not comply, you seek revival of this matter for the aggravated control. So that you will get more money, more benefit. Learned AGA appearing for contender submits that challenge to the order dated 30 January 2026 in SLP number.
SLP. My lords, in fact, this order was based on another case, which was subject matter of the SLP. C diary number I4.
Learned counsel, AGA Bihura.
The complaints of the tribunal, my lord.
Tribunal's order.
Yes, madam.
But the order which we had followed in giving relief to you, that was challenged in another set of the SLP.
No.
SLP is negative. This is what he is saying now.
My lord, this is the instruction has received.
But anyway, you are complying
We are going to comply, my lords,
within 2 weeks.
4 weeks.
Within 2 weeks.
4 weeks, my lords. 3 weeks.
The complaint alleges non-compliance of
Execution case.
order dated 31 compliance of the order. First up. Mr. Behura, the DGA appearing for the contemner, submits that the subject order shall be complied with within an outer limit of 3 weeks. In as much as the challenge to collateral order before the apex court has been declined only on 16 February 2026. First one. The undertaking is placed on record. First one. Next one. In the above circumstances, the contempt proceedings are dropped with the warning to the contemners that should they fail to comply with the undertaking now given, that would be arguably a case of aggravated conduct, which may attract penal penalty in thousands of rupees payable personally by the contemners, in addition to other penal action. Yes.
Item 21
will happen.
21, my lord.
In the event of non-compliance, it is open to the complainant to seek revival of these proceedings.
21 complied, my lord.
You can move a memo saying that they have not done, immediately will take action. Not dismissed, dropped. With the fresh undertaking they have given, they will do that.
Not contempt, repetition.
In writ petition, my lords. My lords, in writ petition there was.
Number you have got. 20. 19.
My lords, 20, my lord. My lords, in fact.
No, I'm sorry, I mistook that it was a contempt matter. This is execution matter.
My lords.
Why he has not complied?
My lords, that is we are going to comply, my lords. That is what we are going to comply.
Execution proceedings you will dispose of.
My lords, we will comply the direction which is put in execution.
AG Behura undertakes that the subject execution case number 71 of 2015 shall be accomplished within a period of 3 weeks. First off, call this matter after 3 weeks. Yes. Sorry, I mistook it to be contempt. 19 is urgent.
Yes.
In the meantime, also dismissed it before the Honorable Supreme Court, man. Yes.
Yesterday only.
Yesterday. Not yesterday.
16.
Yeah.
Item 21.
21, my lords, complied, my lords.
Already just
Complaint.
Your Lordship kindly.
I am giving this. Hey,
But they have.
You have no role, you have complaint over. You have absolutely no role.
Let them give the copy, not the full complaint. That is the.
Complaints to understand.
That is
Complaint. Very.
copy pain na gita.
Complaints running, na? Education to work is only being shown here. What was the order? What is complaints? It is only to escape from the clutches of a contempt court, then I will not.
No, my lord.
That is a salary.
Sum of rupees 4 crores have been paid, my lords.
You have paid now.
My lord. My lords, kindly see page 7, my lord.
To 12 people.
My lord.
Totally, how much you have paid?
For next page, 4 crores 66 lakhs 74,000.
What was the order? The execution case.
Ballot.
They have paid 4 crore order.
Ballot. Up to the 2022, from 22 to till 2026, differential area has not been. But the order on execution was entire differential area is to be released within 8 months.
For remaining amount, you press the execution.
Well, at execution, what has happened in the meantime, report has come. That's why I am drawing your Lordship's attention. That execution case was posted by tomorrow. That is on 21st. But in advance, it was not posted in the board. It was in advance. It has been yesterday. It has been dropped. Even the event, in the event, it will be dropped. But they will have the.
Posted tomorrow.
Tomorrow it was posted,
but it advanced.
It has been advanced behind the petitioner in the absence of the petitioner. There is no date, and that has been dropped because your Lordship was pleased to direct for disposal of the execution case within a time-bound period. They have not done, and they have posted it, knowing very well that it today is being to be taken off in pursuance to your last order. Now, my lord, they have advanced it and already dropped. If in the event it will be dropped, my lord, that period will be remained, my lord, on address.
For that, you have to take proper action.
But your Lordship may observe that may be revived and that may be complied by within a certain time, my lord.
No,
maybe
contempt cannot make an order. It can only ensure compliance of the order.
True, my lord, they have half complied, my lord. That is why, my lord, if it is full compliance, is nothing, my lord. I have to say. Order under execution is not fully compliant.
Alleges non-compliance, non-implementation of the order of the tribunal put in execution. Execution case number?
Execution case number 314 of 2018.
2018. First up. After service of notice, the contemners having entered appearance to the learned AGA, Mr. Behura.
My lords, annexure D3, page 5.
One, Mr. Maheshwara Sahu.
Detailed order.
Education officer.
My lord.
Jajpur has sworn to an affidavit of compliance. First, the said affidavit is accompanied by the office order number 2313 dated 12/2/2026, which mentions payment of a sum of rupees. How much it is totally?
My lords, page. My lords, 4 crores 66 lakhs 74,793.
Well done. 3. First up. In the view of this court, there is substantial compliance. First up. Next paragraph. Learned counsel appearing for the complainant submits that in view of this, even execution proceedings have been dropped and that there is yet other accrual of money beyond a particular point of time, and that has not been paid. First up, for that grievance, petitioner has to, complainant has to work out the remedy elsewhere in accordance with law. First up, in that connection, all contentions are kept open. Next part, in the above circumstances, contempt proceedings are dropped. Next.
Item 22.
Well, it's item 22. The brief was with Mr. G. He has not come for difficulties of.
Notice, my lord. Requisites
have not been given. Requisites have not been given.
Sorry, my lord, why wonder?
Could not requisites within 3 days. Yes.
Item 23.
23, it is compliant, though requisites is not filed.
Yes.
It is the compliance affidavit is.
What was the order? What you have done?
My lords.
Educational trainer.
He was paid, my lords. All the.
Their money is paid.
Not returned, but some dues, legitimate dues, my lord. But I have no instruction, my lord.
They are giving, if there is any grievance, you work out it elsewhere. Now they are given, what is that total amount you have given?
My lords, this is.
Let the sorrow continue.
Pays, my lords, 9 your lordship.
9?
My lord. Yes, it is. No, I'm sorry, my lords, this is same thing.
There is no question at all.
No, no.
Yes, 23.
Next amount is 3,26,000, 22,474.
No, my lord, that is not mine. That is not.
But
Separate word.
yes, ma'am.
Not this, sir.
No, that was previous one.
Previous cases. What was the order?
My lords, the amount has been approved. I seek 2 weeks time for payment, my lords.
Which is serial number?
It is 23, my lords.
Go to 23.
You
have paid the money now?
My lords, money has not been. It has been approved. Only it will be paid by.
When it will be paid?
Lordship may grant 2 weeks, 3 times.
Now you have credited that money.
My lord.
Now it is sanctioned.
My lord.
4,70,000.
Just 7 months.
What was the?
I have not received. Not released to.
It is not released.
The bill they have passed, no?
This is only dated 22, my lords. Only today it has been done, my lords.
No, it only directs filing of compliance report after making the payment.
My lords. My lords, this is
you tell when are you going to pay? That money should reach the pocket of the litigant.
My lords, 2 weeks, 2 weeks.
Yes, we will drop that proceedings. We try to revive it. Complaint alleges non-compliance of this court's order dated 29/7/2025 entered in complainants WPC number 14426 of 2025. First half. The operating portion of the order reads as under. Next. This is Karapur. Entire Karapur. Yeah. Next. Learned AGA appearing in advance for the contemner has filed the order number 4924 dated 20 February 2026 accompanied by memo number 4892 dated 20 February 2026
to the effect that a sum of rupees 4,70,713 for the subject period shall be paid towards arrears of claim of the petitioner. First up. It also directs filing of, first up. The memo also directs filing of compliance affidavit in this content petition. First up. Next paragraph. Learned AGA Mr. Behra, on being asked, submits that the amount now sanctioned would reach the bank account of the petitioner complainant within a period of 2 weeks.
1 more week because
3 weeks. Within a period of 3 weeks. First up. Agreeing with this undertaking, this content proceeding is dropped with liberty to the complainant to seek its revival for aggravated contempt if undertaking is not adhered to. First up, in the case of breach of undertaking, that would be aggravated contempt, which may warrant levy of exemplary costs in thousands of rupees payable personally by the contemners, in addition to other penal action. Okay.
Item 24.
Well, it's here requisites has not been filed.
Today morning I have the instruction with regard to that order has been complied.
Learned counsel appearing for the complainant submits that the order whose non-compliance is complained has been now complied with. First up, in view of the above, another paragraph, the proceedings are dropped. Yes.
Item 25.
25, my lords, compliance affidavit has been filed.
Complied.
Yes.
This is post notice or before notice?
This post notice, my lord, from 18 to 2026, it is complied.
Consider. For cost to be considered the subject representation within a period of 8 weeks. You have considered and what you have done?
My lords, disciplinary action is to be taken because of the mismanagement of funds.
The operative portion of the order in order dated 17/9/2025 entered by this court in complainant's WPC number 5420 of 2025 reads as under. The last part. Up to no person not missing. Up to this. Next paragraph. Learned AGA Mr. Behra appearing for the contempt submits that after looking into the representation of the complainant, a disciplinary inquiry is instituted against
the petitioner,
against
another person,
against
Mahendra Kumar Pradhan. Mahendra Kumar Pradhan, against whom
Mahendra Kumar Pradhan. Pradhan, against whom complaint?
He has alleged.
Against whom allegations were made by the complainant. First time. Within what period he will become completing that inquiry? Again, another 5 years. Panchavarshika Yojana.
That's my lord's.
Within what period he will become?
Your lordship may observe and explain this.
No. Again, explain. One more contempt is complete. It should be aggravated contempt. Within what period you are completing the inquiry?
So that.
Within 3 months you complete it.
3 months will be very too early, my lord, because proceeding.
The inquiry proceedings shall be accomplished within an outer limit of 3 months, failing which it is open to the complainant to seek revival of this proceeding by moving a sample member. Yes. By moving an application, appropriate application.
Item 26.
My lord, compliance affidavit has been filed.
What was the order? What is the compliance?
Representation, consideration of representation.
Consideration of representation. What you have done? Rejected the representation?
No, my lord.
Allowed the I want to examine them. Just to eyewash this court, if that is done, I will take action. Give that, what is that complaint? Let me see.
My lord.
You then go.
That equally got a is right.
So the amount you are paying, earned leave.
No, my lord. That is not regarding
Not this sir.
No, my lord.
This is contempt 6399.
Yes,
This is some difference inside our
oh, my, sorry, sir.
26 sir.
Sorry.
6335. 6335.
It is okay. 6355.
Inquiry I have filed, my lord.
Sorry, my lord. This my lords, this requisites has
I
now
have filed,
been.
my lord. You are saying. It will be accepted, my lord. I filed the requisites.
Requisites you have filed now.
Yes, sir.
Counsel for the complainant submits that requisites have been furnished. First off, register to verify and do the needful. First, okay.
Item 27.
Call on which date it will be. Yes, next.
Item 27.
Requisites may be filed within 1.
27, my lords. This is the
complaint
complaint.
with it.
Oh, no, but
It's the leave salary.
Yes, my lord.
They are already
As well as final pension, my lord.
Final
Final pension as well as year salary.
sanction of cash equivalent of unutilized earned leave in favor of so and so. Control and director. For withdrawal of pension with the limitation value of 90%. So we need to do this. For withdrawal of pension. No, what actually has happened, this passing of orders, that will not help us much. Mr. Bingla,
my lord.
this will not help us much. This will give me the accounts of my disposal, but I am not of my disposal. Very thick, whether pension has reached bank account of the person.
No, my lord.
That's
Lordship may fall on another day, my lord.
or you, if you undertake that in terms of this, the payment.
It has sent to accounts general, my lords. They have to pursue the controller of accounts, my lords. We have already forwarded the pension paper.
Whether controller of accounts was also a party to the proceeding. Look into.
No, I have not made part.
No.
You have not made party. Then their part they have done now.
That will be done, my lord.
This court-wide order dated 19/2025 entered in complainant's WPC number 25667 of 2025 had said as under. Next paragraph. The complainant alleges non-compliance of the above direction. First. However, learned AGA Mr. Behra appearing for the contemner has filed the compliance affidavit dated 19 to 2026 sold to by one Mr. Birendra Karkara.
My lord, director.
Birendra Karkara, who is working as Director of Secondary Education
My lord.
First up.
27. That is 27.
Huh?
That is item number 27.
2567.
No, sir.
3699, my lord.
6399.
But same, the way you are not moving that, I'm reading the same orders here. 25667.
That's W.
256 WPC number 2.
WPC number.
6399.
No, but with WPC only.
WPC 25667.
1925. 25667. It's like that. What you are saying?
It's not surrendered by
No, affidavit now filed is very Yes. Next paragraph. The affidavit is accompanied by two documents. One dated 17/2/2026, addressed to the controller of accounts, Odisha, Bhubaneswar. When the other is office order dated 18/2/2026. First up. The former reads as under. Former being a pension form G. See, former reads as under. I'll check mark this one up to this unit. Yes. Next, below that. The later reads as under. Mr. Behura, on the basis of the accompaniment to the affidavit, submits that the order passed in the writ would be translated into monetary value within an outer limit of 3 weeks. 3 weeks. 3 weeks. First one. Next paragraph. In view of the above, this court is of the considered opinion that there is compliance coupled with the undertaking comply the rest. Therefore, the proceedings are dropped with liberty to the complainant to seek their revival in the event money does not reach his hands. Yes.
Item 28.
Complied, my lord.
Complied.
Yes, ma'am.
That counsel for the first one. But that counsel for the complainant submits.
Compliance affidavit also.
AGA appearing for the contemners also agrees that the order dated 23/9/2025 entered in complainant's WPC 2.404 of 2025 has been complied with. First up, in view of the above, proceedings are dropped. Next.
Item 29.
Order of complaints, the order dated 1/9/2023.
Requisites not filed.
8 weeks.
You have to furnish the requisites now. Not filed. Requisites to be filed within 3 working days, dwelling its contempt stands rejected. Complaint stands rejected. Yes.
Item 30.
If it's are filed, how this matter on. Yes, 33. Yes.
Item 30.
Received the complaints. Copy of the complaints I will do. My lord, my prayer is rejected.
You challenge that.
My lord, grant me liberty to.
That's one. The complaint alleges, go to next fine, 30. 30, 31. 30.
30.
Well, this is 39 of 2026. Yes. Complaint alleges violation of the order dated 20 August 2025 entered by this court in complainants WPC number 22994 of 2025. Full stop. The operative portion of the order as reflected in paragraph 2 and the part that follows, comma, reads as under. Read as under. Next paragraph. Learned counsel for the AGA opinion for the contemner has filed compliance affidavit.
My lord.
Compliance affidavit. First one. Learned counsel for the complainant also says that order in question has been complied with by although his representation has been rejected. Why the order dated? Go to the order dated
21 2026.
20 January 2026. Huh? 20 January. First one. Next part. In the above circumstances, contempt proceedings are dropped with liberty to the contemner to lay a challenge to the said order if so advised. First one. In that connection, all contentions are kept open. Next.
Item 31.
The order dated 12/9.
My lord, requisites not filed, my lord.
Already filed, my lord, 18/2/2026.
Counsel for the complainant submits that requisites have been filed on 18 February 2026. First up, registry to verify, do the needful. If furnished, comma, call this matter on 13.3. Next.
Item 32.
32 here, my lord. Though requisites has not been filed, but we have responded to same and we have filed our so-called reply affidavit, wherein we have prayed for some time because it is in the process to carry out the order, which has been passed on 10/10/2025.
What was the order?
Already appoint the petitioner to the post of PD, my lord.
There is a direction to appoint.
My lord.
Where is that order?
My lord, at
Next to one, my lord.
page 11.
When it was passed?
It was passed on 10/10/2025. This is under the
5 months or so.
That sports certificate for scrutiny, and that is the operating part, my lord. The national level participant treating him as having the requisite sports certificate with annexure 2. This should be done within a period of such and such. My lord, it is in the process.
5 months are over. Keep your officers present before the court. I want to see their black face.
Notice, in fact, has not been issued. But still then, we have taken the kind indulgence that how...
When are you going to issue the appointment? This cock and bull story in contempt court, that is not the thing that will run here. Ask your officers to be present before the court.
May I pray for a breathing time?
What time?
To complete 4 weeks time, you know.
4 weeks for doing another 1 month.
No, my lord. 4 weeks time because it is in the process, my lord. I have filed this.
What? Are they building the tunnel in that mountain, nearby mountain? Issuing appointment order. What is that they are doing, all officers? They are not doing their duty and all that burden is on us. When are you going to issue the appointment order?
Give me 4 weeks time.
Huh? 4 weeks will be long, because I will not give you.
It is in the process. I am responding, but we are responding.
Are you going to come to this?
For that, I need 4 weeks time. You know,
4 weeks will be long. Already.
Yes, man. I am conscious, man. 4 weeks time as a license. If not, then
drop it in the event they do not do. You know what I will do. You seek revival.
But we both know.
I will pardon my lord. Wrongly I have mentioned the...
No, that question will not arise because he is appearing now.
Collector name, my lord. So
Mahapatra, instead of Rautre, my lord, I have mentioned the Raut Mahapatra.
The complainant on oral request is permitted to amend the cost title.
Cost title.
Cost title by properly describing contemner number.
Number 1, my lord.
Contemner number 1 as
Dilip Rautre, my lord.
Dilip Rautre.
Wrongly I have mentioned Mahapatra.
Sudhir Kumar Lenka.
My lord.
Sudhir Kumar Lenka. Mr. Sudhir Kumar Lenka. First off. How many mistakes you have done? Already you have done so many.
Don't, my lord, collector Dilip Mahapatra.
Requisites also not filed.
Mahapatra, my lord, Dilip Rautre, my lord.
That's why.
All are all.
Next paragraph. Learned AGA on appearing for the contemners on instruction submits that if a period of 4 weeks is granted, there would be absolute compliance of the writ in WPC number
13332
made in WPC number 1333 of 2025 disposed of on 10/10/2025. First off, the contemners are put to a stern warning that in the event this undertaking is not complied with, that would be a case of aggravated contempt, which may warrant levying of heavy costs in thousands of rupees in addition to penal action. First off, with the above observation, these proceedings are dropped with liberty to the complainant to seek their revival if adherence is not done. Okay. They will do it now. If they do not do, move a memo. Yes.
Item 33.
33 Miller, Sokas file Miller. In compliance with the order.
What is the compliance?
Yes, ma'am.
Consideration of representation for
This is dated 22/8/2025 at page 11. Whether any compensation can
compensation was paid to the land taken.
But before the
What you have done?
the representation Miller.
Yeah, what you have?
It is at annexer C/2.
C/2.
Yes.
Go to C/2.
The similar set of matters, my lord. The entire original records is with this Hon'Ble court, my lord.
With this court?
Yes, my lord. I have given the number, my lord.
Therefore, you have sought for those records.
Exactly. We have sought for those records. Unless this is returned back. This is in case number 5918 of 2025.
Whether it is returned now?
No, my lord. We have filed this application because it is with the record. Then it will be listed.
And application before whom?
Before the registry, my lord. Before the and it will be listed. Because series of matters therein also CBI has taken up this matter. All the documents has been seized.
Representing the contemners submits that the office of the collector Cuttack has sent letter number 214 dated 6/2/2026 to the learned additional government advocate who appeared in which matter?
In the writ matter, my lord?
No, not in the writ. No, records are where the records are.
59.
So for the records, in the LA case, record number 51/1983, and that soon after the records reach, the decision would be made. First up, in view of that, a period of 4 weeks is granted. First up, call this matter on, take to 4 weeks. Come Friday.
So 20. 20 marks.
All right. Next.
Item 34.
Due to non-compliance of lordship order.
Only that, see, in February, that Cuttack district collector has sent a letter when, see. Yes. Anyway, next date.
What happened, Miller, in Bidanesi project area, there are a series of matters. It is under the custody of the CBI, Miller. For that purpose, it has been seized. And it is matter is in session before this Hon'Ble Court, so far the LA case is concerned. So unless they
Wherever
will
you have
get...
taken the land, there will be fraudulent cases. But wherever the land is taken, to the owners you have to pay the compensation. You can't say some CBI case is pending, will not pay. Then give back the lands. That order I am going to make in the contempt. There's one famous judgment by Justice Shiv Shankara Bhatt and another companion judge, Vasant Kumar. ILR 1986 Karnataka. Was it? State of Karnataka versus G. Lakshman, where the direction was for issuance of the gun license to the gun factory, Shiva gun factory. They did not comply with. Therefore, Writ Court granted the gun license, the factory license for producing the guns. Not just gun license, gun factory license. ILR 86 Karnataka. We have that judgment. Just go through. Therefore, our powers are enormous. We can't simply say order is implied, complied, not complied. No, not that way. If order is not complied, whatever order you would have made, we will make that order here itself. Yes.
Due to non-compliance of lordship order, lordship directed last exam.
Yeah, State of Karnataka. G. Lakshman.
G. Lakshman.
Yes, 1986. ILR 1993 Karnataka 1430. But it was decided,
86.
No, 93. My memory is playing trick with me. 93 it is. They referred to Kalinga tubes and etc. I remember.
Kalinga tube, Odisha.
Yes. Next. 34. What was the order? About circumstances. It's in 1/6/1994 as the responding date for sanctioning and releasing the grant made in favor of the appellant under the provisions of grant in 1994 as against the first post of lecturer. With perspective, which would include arrears as well. The above exercise to be accomplished within an outer limit of 2 months. Yes, brother, what they have done? First time it has come.
Yes, notice requisites for issuance of notice not received, Miller.
Requisite already filed, my lord. Requisite already filed.
When it is
filed in time, my lord.
When it is filed?
Today filed.
When our order was made?
Order, my lord, 4/2/2026.
How many days you have to give requisites? What's the rule? In contempt matters, rule says within 3 days.
3 days.
And now you are saying it is done today.
But however, my lord, we have responded to it because of the order is there, though it has not been filed. But my instruction as I received before lunch, my lord, there in a state in the similar matters, it has been moved to the Hon'Ble Apex Court, my lord. That SLP number, diary number also I have given, my lord. May I submit the hard copy, my lord?
Now what I should do? Unless there is an interim order in the hands of the Honorable Supreme Court, on the ground that you have challenged it, and there must be some delay also.
It is on 18/2/2026.
When the order was made? Order was made 31/10/2025. When I ordered arrest and detention, all these things happen.
Because similar some matters are there. Can we give some time?
Counsel for the complainant submits that requisites have been furnished relatedly. First off, delay is condoned. First off, registry to process the same. Yeah, call this matter after 8 weeks.
I'm filing this reply. It may be taken on record.
No, why? What for? I'm not listening with that.
So far, this filing of the...
Unless stayed, we will not, this one. 1 second should that. Call after 6 weeks.
Yes.
Call after 6 weeks. Give some date. Call on.
8 weeks, my lord is saying, because
26-3. On 26-3, we'll call it. 27 is Friday, na? Friday. So,
April 1st.
10th of April.
Yes.
All right. Next.
Item 35.
Maybe.
Yes.
Order dated. Next chapter. Order dated 11/8/2025. Page 7 minor.
Consideration of representation.
Minor.
Not considered. Yes, issue police notice.
My lord, steps for issuance of the notice to be taken by the petitioner.
Requisite has not been.
You have not given the requisites.
Not taken. That is the noting, my lord.
Since first time.
You how many times it should come?
This is first time, my lord.
Huh? Is it first time it is come?
My lord.
Is it so with that? Page number 35.
My lord.
It was already.
On 4/2/2026, we have issued notice.
Earlier occasion 4/2/2000. Possibly my
No. The request is to be punished within 3 working days, failing which complaint stands rejected. If for you state, come on, call on 13/3. Next.
Item 36.
This one, the requisite already filed. 19/2/26.
19 to yesterday.
19/2, my lord.
Yes, ma'am. Yesterday.
Huh.
Sorry, notice for notice.
It was ordered when?
My lord, Annex Suran press 11, my lord.
13.
32. All right. Same order. Yes.
Item 38. 37 has been disposed of.
The claim of the petitioner, man.
Compliance report has been filed and it has been taken care of under Annex A/1.
So that counsel for the complainant submits that the subject representation having been rejected, the complaint should be permitted to lay a challenge to the same, and with that liberty, the proceedings be dropped. First, I agree. But in the most circumstances, the proceedings are dropped accordingly.
Item 39.
Sorry, my lord, today we have filed the requisite.
Same order. Yes.
Item 40.
Complied with me. Counsel for the complainant reports that there is compliance of the order. First, in view of the above, proceedings are dropped. Yes.
Item
You
41.
have filed the affidavit also.
Yes, sir.
In that affidavit is fine.
Yes, sir.
We have communicated the same. We have also filed the compliance on 17/2/2026.
The compliance affidavit is also fine. First, in view of the proceedings are dropped. Yes.
Item 41.
41, I have already filed the request. Noting is that, man.
118.
Already filed.
Because it is in late, that is the noting, reissuance will be made.
Yes. Next.
Item 42.
Please, my lord, see. In this matter, last time my state councillors take time to discuss with the officers. And today also we have been informed about that.
Lord, 42 here, counter agenda has been filed. But
yes,
apart from that, there is a binder who is working and out of him.
Hey, will you argue with him?
And not out of employment since 1994.
Out of employment?
Yes.
When he had entered, gained entry to the proceeding?
Entry in 90, it is in
18 to
1994.
18 to
1994.
18 to 94 to what? Next what happened?
Illegally terminated discussion case 27/8/1994.
94.
When he gained entry?
February and August.
February 18, 1994.
19 February 94.
18 February.
18 February 94.
94.
Yes.
And terminated on?
27/8.
August.
27 August 94.
Only 6 months you have worked.
6 months.
Yes, my lord.
What should be done?
No, I have challenged that order in Odisha Administrative Tribunal. As similar situated candidate have already appointed and regularized in that institute. And Odisha Administrative Tribunal said that if in such case, the case of petitioner should be maybe considered. Then I have filed a representation before the printing press director. It was rejected.
Rejected on what ground?
On ground that there is a lesser workload and scarcity of money. Lesser workload and non-availability of funds. Yes, on that ground only. Lesser
Others who were given employment,
yes.
How long they had worked?
After my appointment, after 1 month of my appointment, they are appointed as a casual binder. They have regularized, but I was terminated.
But what can be done? Of 1994 it happened.
Yes, but I have pursued the case with the administrative tribunal.
Tribunal, when you had filed the case before the tribunal?
Yes, 1994. 1994.
It is filed on 96.
OA number?
2082 of C, 1996.
In this type of thing, what can be done? OA number?
OA number, latest OA number, my lord, 3187 by 1998, page number 23.
You filed in 1998?
My lord, sir. No,
first year.
The first one is filed, yes, 96.
OA number?
2082C of 1996.
Even there 2 years.
Yes.
There in the OA 2082 of 96, what the tribunal said?
To consider the referendum.
Application.
Order dated?
It is order dated 25/7/1996.
What happened in 3187 of 94?
That was disposed of on 9/11/2017.
Saying?
Having no...
To consider my case.
Again?
Yes.
9/11/2017.
98, my lord. 3187 by 1998. Another way.
3187 of 1998.
Yes. Order dated 17 July 2013. Same order was passed again.
2013?
Yes.
What is your client says now? Age of your client?
Age is, I am ascertaining that it is 56, 57.
Yes.
However, I have also, out of the way, I have consulted anything can be compensated so for the monetary other.
Correct.
So they sought for some time that I am asking my friends that if at all it is anything can be compensated because it is a question of 94 million.
Correct.
In the meantime,
give some money.
Exactly. That I am talking with the authority that if something can be done because that is the NTC certificate, National Trade Certificate is required at that point of time. Because of the workload,
NT certificate.
They have been allowed casually for some times. For a little bit of period of 6 months to 8 months they have worked.
All other
So I am trying
casual, even their counter they have agreed. And other employees are working there. Only me I have engaged alien. That is in their counter.
At least 2 weeks be given. By that I can
come back with at the request of Learned AGA who submits that, he would confer with his official client as to whether some monetary compensation can be given regarding being held to the advancing age of
56.
We said to be 56-year-old. Okay. You just see what can be done.
Yes.
See, but now they have fought. What is his fault? If we keep the cases pending for years,
Yes, my lord.
what he should do? Yes.
Item 43, obligement.
Yes, relating to matrimonial case, my lord.
Yeah.
Present petitioner filing a execution case in Family Court Bhubaneswar, which is pending for comply of the judgment of the Honorable High Court.
What the judgment says?
The judgment says the maintenance and permanent alimony, that is 13 lakhs 50,000.
He
And
has
other,
not paid.
only 10 lakhs my lord paid and other
3 lakhs ought to be paid.
Yes, my lord.
Who appears?
I appear for the husband. Lords, let a copy be served on. I don't have a copy of the writ petition.
Give copy. Yes,
And I have filed a review of the judgment of the Honorable High Court, which is pending.
Anyway, that unless it is reviewed, I made direct approachment detention of the husband. All this matter on 13.3.
13th, my lord, I will not be available. Some other day.
No, I sit only on 13.
13th?
Yes, 13th.
I am out of town.
What can be done? As between the lawyer and judge, judge's date will prevail.
I am some other date.
But all these years, how many years? Matter is pending here. Matter 2022. This code of 1823. What is your client doing? What is he?
He is a clerk in the Khurda Judiciary.
Government servant, my lord.
Government servant and going judiciary.
Yes.
We can't advise your client to escape from the clutches of this court.
Yes, I have advised him. We have a better than fair case on merits in the review petition. Let him serve a copy. I'll serve it.
Yes.
I'll file a reply. My lordship may accommodate me on any date except 13th. 13th I'll not be available. That's what I'm saying.
You copy. You copy.
Today I've served this.
Right now you give a copy for this matter next Friday.
There are 10:30. You want to fix some from 10:30. You want to fix some date on 10:30.
No. It should be immediately done.
But there are 20 months.
20 March. Call on 20 March. Yeah.
Most of it.
Item 44.
You will get money. I know that. Yes.
May I please your question? My lord, the matter relates to an appointment of contractual guest faculty lecturer.
Contractual guest faculty.
My lord, your lordship has passed the order on 18/8/2025. It is at content petition page number 8. Till next date of hearing, no appointment engagement order shall be issued to any candidate in respect of the position post to which the petition was engaged as mentioned above. My lord, flouting your lordship order, the contender, the opposite party, has given appointment to a person by substituting the contractual guest faculty lecturer by another contractual employee, which is gross violation of the canon of judgments.
Who are the contender? The notice was not issued to them.
No, my lord.
First time it has come.
Yes, my lord.
Who are they?
Say the principal of concerned college.
Very good. Nati Prava Mahapatra.
Vivasnath, principal cum secretary.
Police notice, the secretary. Yes.
Now, my lord, one prayer, my lord. After 1 month, the contractual employee would be terminated again, and another contractual employee would be engaged.
Friday will come now.
Yes, my lord.
Yeah.
Item 45.
You have to give repeat now.
Yes, my lord. Today, on Monday, I will.
This is in 3 working days.
Okay.
Item 45.
One completion ordered 28.
We have filed the compliance report on 9/2/2026.
Decision has been taken on the representation.
Yes, ma'am. That has been duly
What
complied.
decision you have taken?
Well, at the page 10, my lord. Accordingly, representation dated 12/2000 were hereby rejected for want of legal merit and statutory support. However, it is clarified that the
Complaint alleges the non-compliance of order dated 20 August 2025 entered in complainant WTC number 22661 of 2025. The operative portion of the order, that is 3 Please, in that paragraph. Next paragraph. Learned AGA appearing for the contemner submits that already a decision is taken on the subject representation. Wide order dated
9/2/2026.
9/2/2026. And therefore, there is due compliance. First one, I agree. Next paragraph. In view of the above, the proceedings are dropped with liberty to the contemner to lay a challenge to the said order if he is so advised. First one, in that connection, all contains to that program. Next.
Item 46.
Yesterday, they have filed a compliance affidavit and representations have been rejected, but all contents are had not been complied with. Yes,
This court, next. This court wide order dated 25/9/2025 entered in WTC number 26861 of 2025 had a directed consideration of petitioner's representation in accordance with law. That representation was for what?
Representation for resuming the duty because from 18 as a primary school teacher, my lord. She was debarred from resuming the duty since 1998, my lord, and giving all the medical certificates.
This is all about the unauthorized absent for more.
They have not terminated. They have not.
It is written under 72.
Any disciplinary proceeding even initiated against it.
Mr. Mohanty, learned AGA, representing the contemner, submits that a decision has been taken in the subject on the subject representation
18/2.
Wide order dated 18/2/2025, and therefore there is substantial compliance.
26. 26.
26. 18/2/2026. First now. Have you filed the order?
Yes, ma'am. I filed the order and so copy, sir.
A copy of the order is also filed along with compliance affidavit.
Yes, ma'am.
Yes,
They have also received.
First now. I agree with the version. Next paragraph. In view of the above, these proceedings are dropped with liberty to the complainant to lay a challenge to the rejection order. If he is so advised. All contentions in that regard are kept open. Next.
Item 47. Item 47.
They have filed one compliance affidavit, but not as per the Lordship's order spirit, Lordship. Your Lordship
that is so challenging.
No, Lordship, your Lordship have a glance only to your Lordship's order.
Speaking order.
So only I am praying for. My Lord, only I am praying for.
In view of compliance affidavit. If there is any grievance, it is open to the complainant to lay a challenge.
Only my prayer is only your Lordship.
If the contempt is a matter between the court and the contemptor, not you.
Oh, your Lordship, only I am your Lordship, only.
Item 48.
My Lord, only my prayer is there.
Item 48.
Only it is, I am excused to
compliance.
No, Lordship.
Therefore, if there is no compliance, you go and challenge this order. Yes.
Lordship, it is there. Your Lordship is directed as per the Rajiv Sav case, Lordship. He is not whisper about the Rajiv Sav case.
That is the ground for challenging that rejection order. How can contempt court say whether that compliance order is right or wrong? Can I enter into that examination?
Because your Lordship directed the similar person has been given the benefit. It is Annexer 7 and Annexer 5.
Yes.
But it my Lord, we pray for some time.
What was the order? Well, that order was made on 21/8/2025.
We have moved to the government, my Lord. Some time is required. In the last chance, we may.
The last column. Yes. Next.
Please, my lords. Last occasion, twice the notice was issued to the contempt, my lords. The operative portion is at page 27. allotment and executing registered repairing conveyance in favor of the petitioner.
Subject allotments by executing and registering required conveyances. Who are the contemners?
The appropriate is the contempt number 2.
First time it has come.
No, it's third time.
Third time. Yes, who appears for?
LIC.
There are a panel of lawyers, Mr. LIC of India.
So this was done when? Service report is not received.
Yeah.
To take fresh notice once again. Because unless notice is served, we can't do anything. If once it is served, we can do all the.
Malus. I will through speed post also, Malus, both ways.
No, in contempt matters, it has to go not by speed post. Actually, in contempt proceeding, there is a separate procedure. Anyway, this court quite order dated this. Why it has not served? Which police station?
Airport police station.
Huh?
Airport.
This court, why the order dated when it was issued notice?
30th January.
Order dated 31/2026 has directed issuance of police notice. When did you file the requisites?
3rd of February.
Counsel for the complainant submits that he has furnished the requisites on 3/2/2026. First one. Why the court order dated 31/2026 has not been complied with by the police is a question for consideration. First one. The police inspector of Air Force Police Station.
So I need to check my lords because under which
Let's look into it.
Malus, I will tell you. Lordship may pass over the matter within 2-3 minutes.
Police station is directed to be personally present before the court on 13/3/2026. However, for offering the explanation of non-service. First off, however, if service is in the meanwhile done, his personal presence shall not be required.
State government officials are not parties. Still then your lordship directed the service a copy.
Provided he receives the.
That we are not holding any brief also. He has not supplied any copy to us even. State government is not a party. No, officials not official are not contempt before lordship.
This is LIC corporation. LIC corporation.
LIC corporation.
My lords. In fact, this was not communicated to police concerned. Your lordship grant some time, we will communicate him to serve the notice. Provided he got the notice, my lords. Unless process is given, my lords, unless we get the copy, how he will communicate, my lord? That is the problem.
No,
the contempt. Registry has not
sends order to the police without intervention of government advocate because it is a direct notice.
If it is done,
they have to file requisite for that one.
Yes. Next.
Next item, my lord, the order of the Honorable Court has been complied with. In the meantime, we are supplying a copy.
My lord, only salary of the petitioner has been withheld since July.
What was the order?
Order to dispose of the comprehensive representation.
That's all.
Yes. 3 months have been released yesterday, but now the rest 4 months have not been released. Salary of the principal, arbitrarily, there is no
salary that we have specified the period from July 2025 to January 2026.
Yes.
Last line.
January 26 is paid.
No,
yes.
They have only given the salary yesterday on from July
2025
and September.
No.
And yes,
where is that compliance order? So release the salary of the petitioner principal in charge so from the month of July 2025 to the month of January 2026.
Well, this is the noting. But for now, this is the director has been issuing one type of order, and the sub collector is issuing, your lordship, this is the order I have. Only from July to September has been released. July to September.
I do not.
So yes, I am giving.
I am under the impression that this is the compliance.
Copy.
But if it is not compliant, my lord, that will be.
We saw it on 33. 33. Ask your
Yes.
officer to be present before the court.
In the meantime, if it is compliant, they
did not.
Yes.
Does it AGA, Mr. Panda, appearing for contemner, has filed office order dated office order number 9546 dated 19/2026, which reads as a next paragraph. Learned counsel appearing for the complainant shows this court a copy of sub-collector's order.
My lord, note sheet is there from
a copy of note sheet of the sub-collector.
But no signature. On the second page, my lord, page 2, only July, August, September.
My lord, yesterday only we have passed the order and the note sheet has come note sheet has come to his hand. I do not know.
Brother, there is an order for payment of salary.
Yes. That we are bound to do that. We are bound.
Director Higher Education sends it for July to January 2026. The sub-collector says it is up to July to September.
No, my lord, but this is the note sheet and there are next page 2, July to September 1.
That's fine.
Yes.
That cannot be done, my lord. I will ensure it. I will ensure because it is prima facie, my lord. I am unable to comprehend that how that it has come to his hand, my lord.
Because see, for that you may take action against the officer.
Yes.
But whatever money he should get, he should get.
He has to get. Yes, because we have passed that order. We have to implement our own order also.
Counsel appearing for the complainant submits that the sub-collector has drawn a note sheet for payment of salary from July to September alone and not up to January as stated in the office order dated 19/2/2020. If that be so, it will be a serious matter for treating at the hands of contempt court. First off. Next paragraph. Mr. Panda, learned AGA, very fairly submits that he would instruct his officers to make a payment of the salary during the period between July 2025 to January 2026 in terms of office order dated 19/2/2026. First, if that compliance is not adhered to, if that undertaking is not adhered to, the who should be present before the court?
Sub-collector.
The sub-collector of Kendrapada shall be shall be personally present before the court on 13/3/2026 for offering the explanation. First off, if the explanation is found to be not plausible, court may direct penal action.
Lordship may kindly observe that in the meantime, if it is not necessary.
Yes, I have said. We have said already. If in the meanwhile it is done, no question of that question.
Personal preference, grateful.
This whether they want commission or what, why they are doing
No, I do not. I feel this is totally absurd thing, my lord. If the higher authority has passed that order, who is he to? It amounts to insubordination even.
Next.
Pardon, item 14. PS is airport PS office.
Airport. Airport police station.
Well, sir, I just spoke to the a person from the airport police station. As it is not the jurisdictional police station, they have returned the letter to the registry. That's why it is not.
No, they have to send it to the jurisdictional police station. Why they returned?
I don't know, I just got it.
They said like that.
Yes.
Let him come. If it is not, if he is not the jurisdictional police, then he should send it to jurisdictional police. He can't say that, no, I don't have jurisdiction, therefore I will not look into. We are not asking him to investigate into the things.
Then, my lords, it is the airfield police, my lords.
Huh?
Then it is the airfield police.
Airfield police.
Airfield police station.
Airfield PS. Airfield PS. Yes.
It's a case of regularization of the petitioner. And my lord, the matter is pending for the compliance. But the so-called affidavit has been filed by the OP number 3, who is saying that I am not the authority. Authority at the government. Government is considering. So 2 months or at least 4 weeks more time may be granted.
Whether he was a party to the proceeding?
Yes, party to the proceeding.
Whether did he take up the contention in his object statement? I am not the authority to take the decision.
Yes.
Where has he taken?
And he has moved.
Now,
he has moved before.
The order was made. Or when the order, when the in the petition he would have taken the contention, I am not the authority. He cannot keep quiet and allow the court to pass order. And then saying that I am not the authority, we will not hear.
No. He has been arraigned as a contemner here. But direction was not against that.
Against whom it is given?
It was given of circumstances. These petitions are disposed in terms of order of a cognate case mentioned above. Condition mutatis mutatis. In the cognate case, the following relief was granted to the litigant. So in similar matter, regulation, to benefit of regulation appointment on opposite party to complete the entire exercise. Opposite party number 3 was directed to comply. In the cognate case, the Lordship also said that the cognate case direction will also be applicable here.
In fact, the case, cognate case is affirmed by the Supreme Court.
Yes, we are going to. We have to comply, my lord.
When are you going to comply?
Only 4 weeks time may be granted.
When it was decided?
It was decided on
August 2025. 6 months, exactly 6 months ago. What is the explanation for not complying all these days? And what's the guarantee that you will comply within 4 weeks? Now, for 6 months, you have not done anything. Why are you harassing the successful litigants? Because they have succeeded.
No, not like that. Our intention is not that. We don't say.
Otherwise, court has to presume something else. If they say we will comply with the court order only if this and this done, we will tell in the order itself.
But Lordship may grant 4 weeks time. If we fail to comply, Lordship may impose penal action.
We'll give you 4 weeks. Learned AGA Mr. Panda appearing for the contemner, having argued the matter, very fairly submits that the order dated 21/8/2025 will be complied with in letter and spirit within a period of 4 weeks. And a compliance report will be submitted to the complainant as well. First up, call this matter on 4 weeks. 20 March. If comply earlier, the contemners are hereby warned that should they fail to adhere with the undertaking given, they may run the risk of very stringent penal actions, which may include arrest and detention. Yes. Next.
On behalf of the Honorable Senior Mr. Pujari Manar, to submit that by the order dated 4/2/2026, your Lordship directed to issue emergent police notice. Till now, nothing has been communicated to the petitioner. After issuance of the.
Have you given?
My lords, may I submit, my lords? My lords, latches is there. We need 3 weeks time for compliance.
You will report compliance.
Yes.
Learned AGA Mr. Behura, representing the contemners, submits that The order dated 24/9/2025 entered in complainant's WPC number 22383 of 2025 will be complied with in letter and spirit within a period of 3 weeks. First off, the contemners are hereby warned that in the event this undertaking is not complied with, they run the risk of arrest and detention. Very stringent penal action, which may include their arrest and detention, apart from levy of exemplary costs in thousands of rupees. First off, in the above circumstances, these proceedings are dropped with liberty to the complainant to seek their revival by moving a memo in the event the undertaking now given is not adhered to.
Matter pertains to regulation, and your Lordship was pleased to issue notice on 30th of January 2026. Matter relating to regulation of the petitioner.
In terms of Jago?
In terms of Jago. That was the order, your Lordship. To consider his representation, taking into account the recommendation of the authorities, and so also the judgment that was passed in Jago.
Notice was not...
And 30th of January 2026, notice was issued to them.
30th notice was issued?
Yes, your Lordship.
Whether it is served?
My Lord. And it appears from the causes that a show cause affidavit has been filed by OP number 3, 4 and 5.
3, 4 and 5 they have filed now?
It appears from the cause list. The copy has not been served.
My Lord, compliance affidavit we have filed, my Lord, on yesterday only.
Whether regularized or rejected?
Rejected, my Lord.
Show that whether rejection is bona fide or not, we look into.
We have e-filed.
Yeah, you can.
The last page.
Copy may be done.
Last page, last.
How many years of service you have put in? But what, you don't read the papers, you come here as if you are coming to some marriage chowdhury?
You know, your Lordship, I don't have the copy of the petition, your Lordship. I'm afraid. Only the content petition. I'll just go through this. In 2011, your Lordship. The 30th of November 2011, I will issue the engagement order.
You challenge it. They have said Uma Devi and other things. This is a lawyer drafted order to make out. But anyway, you challenge it. Now, if I pass some order in your favor in this, then that order may not be sustainable.
My Lord.
Okay?
The copy of the same may be served upon.
My Lord, that is his copy. Lordship's copy. Lordship already, it is e-filed.
This court filed order dated 6/8/2025 in complainant's WPC number 21460 of 2025 had directed consideration of his case for regularization in terms of Apesco decision in Jago versus Union of India 2024 INSC 1034. First off, the period for compliance was given 3 months. First off. Next paragraph. The complaint alleges violation of the above order. First off, after service of process, the contemners have entered appearance through the learned EGA, Mr. Panda. First off, they have filed a complaint affidavit dated 19/2/2026. First off, a copy of the order dated order number 3705 dated 11 February 2026 accompanies the same. First of, by the said order, the claim of the complainant for regularization has been rejected by quoting apex court decision in Uma Devi, Chago, etc. First of all, I agree with the submission of Mr. Panda that there is substantial compliance of the order. First of all. Next paragraph. In the above circumstances, these proceedings are brought with liberty to the complainant to call in question the rejection order if he is so advised. First of all, in that connection, all contentions are kept open. Next. Next.
Here the 54. The judgment dated 3925. 3925 is the judgment. Direction was that order of the authority was passed and direction to restore the benefit,
pension, etc.
Yes, sir.
Actually, washing this one, so withdrawal is directive offense to sanction and pay to the petitioner regular pension. This is a direction, not for considerations.
This is the judgment, not complied.
Not complied.
Not complied. I am filing an affidavit also.
Notice has gone.
Yeah, notice has gone. Now, in the meantime, I am just filing an affidavit. What they have done, my lord have said, I was getting 4,600 as the grade pay and retired. Now, they fixed the pension in the 4,200, which they have intended in Annexure 3, which has been passed by man. Very peculiar order, my lord. They have overreached virtually my lord's order.
No, that you have to, now they have sanctioned the pension.
No, pension, the order was, just one second.
Now they have sanctioned the pension.
No, pension sanction, the order was, I was getting my pension. What they have done, they have issued an order.
We are getting pension at what rate?
Last 4,600, grade pay of 4,600.
You are getting pension on that basis?
On that basis. They directed to reduce it to 4,200. I came before this honorable court. And this honorable court set aside that order and directed all this judgment that yes, he is to get all the benefit with 7% interest and everything. But now the control of account, despite receipt of the order, is stick to his own earlier order, which has been set aside. That 4,200. That is, I have brought it through this affidavit. Virtually, he has stick to his own order. That is the audacity, man. That I want to say. In the process, he has lowered my last pay drawn and fixed the pension. What she intended, the authority has intended in Annexure 3, which has been set aside. That is the no compliance affidavit filed.
Mr. Panda, appears to be a case of contempt. Because the very order which fixed 4,200 was quashed. Now he has done it what? Again 4,200.
Same thing. In the reduced rate. They have sanctioned it.
Just examine.
I have to examine and I have to also file an affidavit before lordship for its full compliance with your lordship's order.
Full compliance.
Full compliance.
Otherwise, tell you.
Definite.
Nothing but a fraud on the court.
Yes, I admit.
That order is quashed and still she
cannot.
All this matter on 13/3 at the request of learned AGA will submit that he would confer with his official client and come back.
For full compliance.
Yes. From it still. Just wait. Because all these post notice matter. Wait, we call only few matters now. 54 are over now. Another 24. Another 2-3 matters.
61 and appearance was there.
Personal appearance, 62.
Item 62. Today I appear only about the Dharma University, registered Dharma University.
Whether there is compliance of the order?
No.
Not compliance?
No.
Where is your point?
No, I am for the petition.
Not for the petition?
He is for the, I am for the contempt. Today I appear.
Yeah.
The contempt notice and the petition also not provided to me, my lord.
Give copy. Call on 13/3.
The serial number 62. 62. All right.
Millard,
I saw the copy.
Millard, so far this 65 is concerned.
64 is personal appearance.
64 Millard. The last order was dated 13/2/2026. Here Millard has specifically directed to issue emergent notice. In fact, notice has not been received because last Friday.
Received on which date?
Millard, not yet received, Millard. Not yet received, but learned AAC has taken the pen, Millard. Yesterday they have served the notice over the WhatsApp, Millard. He has also served the notice upon the DO, Millard. This is the receipt, Millard.
You have heard it now.
And a presence in person, Millard.
Okay. Pursuant to our
order dated 13/2.
Pursuant to the court's order dated 13/2/2026. Come on. What is he? ASC.
IAC.
Inspector in charge. Inspector of Police in charge.
Basta Police Station in the district of Baleshwar.
Mr. So and so of Basta Police Station
in the district of
is
Baleshwar.
personally present before the court and submits that he has already served the court process on the contemners on
today.
This day. This day.
This is the receipt, Millard.
First up, he also exhibits the receipts of service by way of how personal.
Yes,
personally served.
Through his officer, Millard. Sub Inspector was there, personally received, and they received the copy, and this is the stamps and acknowledgement, Millard.
By the contemner.
Yes, Millard. The DO. Block Education Officer.
Yes, Block Education Officer is not here.
Not here, man.
He has, because received today, Millard.
He has received it today. Mr. Hon'Ble of the AGA appearing for the contemner BEO seeks a short accommodation to take the instructions and come back. First up, call on 33.
My lord, your lordship, this is a GPF matter, my lord. They are not really the GPF. Petitioner is really.
Release, Millard.
33.
On the order we are trying to comply, Millard.
Yes.
Millard, the personal appearance that may be because
personal appearance of personally present we have said, na?
Yes, ma'am.
Yeah. The personal appearance of the concerned police officer on the next dates of hearing is dispensed.
Item 58, your lordship has issued police notice to the contemners. And with a person notice that non-compliance of the same
58.
No notice has been received by the office of the accountant general. Also.
Yes.
Has it no notice is served on you?
Yes, I have served.
You cannot serve. What?
In the court, I have filed in the court, my lord.
You have filed already?
Yes.
Requisite service.
Noting is there, SR not back.
You let me kindly say.
Noting is there, SR not back.
Order was passed on 4/2/2026 and on.
When it was sent from here. You should see, they should tell them registry when requisites were furnished, when notices were sent, all that should be available to me.
You should file an affidavit that
why should I have? They are not copy notes. How should I file?
Now you
copy whom I
don't. You have one more set of copy. You want argument or you want relief?
No. As per the order, I have.
Give one more copy. Don't waste time now. Give one more copy to him. Learned senior panel counsel, Shri.
Standing counsel for accountant general.
For the accountant general. So and so appears. For the which contemner?
Contemner 1.
No contemner. Actually, there is no allegation against the accountant general. There is no role of the accountant general. IAP has implemented the party. I don't have knowledge.
Let us see. You file your report. Appear for number 1.
Yes.
He's giving it now. You give that.
Yes, I shall give just.
First of all, this matter on 13/3.
In the meantime, we'll serve a copy of the application.
First of all applications, all petitions, all papers. You give one set now.
Yes.
Yes.
Including repeat sum up to.
Counsel for the complainant to serve entire complaint along with all the documents on the learned standing counsel right now. Okay. If that is done, call this matter on 13th. Okay. Otherwise not. Yes, next.
55. Non-compliance of order dated 13/8/2025. The police notice is already given.
Third.
My lord.
Police notice served on them.
My lord.
Are you sure that service is done?
Subject already filed.
Await service of notice. Call on 13th. Next.
55 also.
Same.
56 also.
Same.
My lord.
57 emergency notice of the police notice are issued on 4/2/26. I have filed the requisition on 4/6/2. Next date. But noting that SR not filed.
Await the notice. Yes.
29, your lordship direction, my friend is appearing on behalf of the contender. And they have filed one internal application seeking some good time for compliance. That is the IA filed. So as I am going through the amendments in the IA, I think lordship may feel it proper to give some good time to them for compliance. Because they have filed an IA seeking some time. IA number 107 of 2026, lordship.
Actually, they were filed in WPC.
In the contents.
Contempt, we don't have power to extend period listed by the contempt.
My lord, I am telling why I have filed such IA.
But we have no power. What all you say is
My lord,
war took place in
my lord, I only pray.
So Chandra Bose is born in cut. Everything is true. But we cannot pass order.
My lord, I only pray 8 weeks time. My lord, I am telling my lord.
You are telling all right, but I am telling you that contempt court cannot extend the period. Writ court can.
My lord, for compliance.
For compliance only, you have to make an application under section 148 of the CPC, read with 227, for seeking extension of the period. That the writ court, whether I sit or others, I do not know. I am only contempt court, judge of contempt court. I have no such power. Therefore, I have to take action only. Unless you move that court and get this extension.
My lord, may only peruse the writ petition of what order have been passed in the writ petition. My lord, may kindly turn to page 12.
Well,
in fact, page 13. Para 3 subpara. In the above circumstances, petition is disposed of directing opposite party
subject representation and
inform results such consideration to the petition within a time limit of 8 weeks.
Yeah.
It is hardly need to state that all the stakeholders should be given an opportunity of hearing.
Yeah.
My lord, here it was directed to the opposite party number 4. My lord, may see page 11. My lord, may kindly turn to page 11. Who is the opposite party number 4? The Register Director, Regional Director, Council of Higher Secondary Education, my lord.
Yeah.
My lord, my instruction is there is no such authority in that designation, my lord. Actually, Sambalpur zone is headed by Deputy Secretary, my lord. There is no such authority. That is the reason, my lord, there was a delay in compliance. Yeah, but however, we have already issued a notice. I'm not standing in the way. My lord, I'm not standing in the way of order. We have issued them a notice. Pursuant to
learned panel counsel.
My lord.
Panel counsel Sri so and so appearing for which OP?
The only OP.
Contempt.
The whole contempt submits that the process is being done in terms of the order dated 24/9/2025, and that the task would be accomplished within an outer limit of 8 weeks.
8 weeks. But 8 days.
8 weeks. First term. In the next paragraph. With this proposal, learned counsel appearing for the complainant is also agreeable. First term. In the above circumstances, this proceeding is dropped with the warning to the contemner that if the assurance now given to the court is not adhered to, that would amount to aggravated contempt.
Gratefulness.
And serious consequences will follow. First time. With the above, what was this? What? In the event of non-compliance,
comma, it is open to the complainant to seek revival of these proceedings.
Grateful.
For aggravated contempt.
Grateful.
Next.
60 and 61. Lordship may pass the similar orders where your Lordship have.
48 what your Lordship is.
48. What you have done in that? Column 33.
33.
33.
Yes.
See, serial number 40. Print that order here. Yes.
63.
Sixty-three, my lords, pursuant to Lordship notice through police. We are filing a show cause today on the grounds therein being that in the meantime, there has been some communication with the government as regards your Lordship's order was as regards regulation in a compassionate appointment ground. So there has been some communication which has been annexed to that. And secondly, stating before your Lordship that a writ appeal has been filed and that has been already registered but not yet been listed.
Column 33 at the request of learned panel considers to Patnaik appearing for the contemners. Finally, before that, so if nothing happens, then you know what I...
Definitely.
Yes.
Definitely. I bought.
Yes.
65.
Appeal to 26, the Lordship issue police notice. But failure to order has not been complied.
Last notice.
Last Friday notice was issued, my lord. Yes, sir, not back. Same.
Column 23. Yes.
65 to
66 and 66.
Same. Yes.
23.
23.
65 to 67, similar.
Same.
68.
68 also.
68 also Lordship, same Lordship. May Lordship.
Back.
Yes, sir, not back Lordship.
Yes.
Yes, 7 are not back. Yes, sir, not back.
Same order. Next.
7 also same.
Yes. Same order.
Item 71.
Yes, sir. It's
71, 2 and
yes, 71. Copy number 2. Now, what it's already received.
Let it receive, my lord, in item
671.
71. 71 I have already filed, my lord, OP number 1. The university employees, my lord, still the OP number 1 filed is focus, my lord.
Compliance or what is that? Compliance report. Compliance affidavit.
No, my lord, it's focus affidavit.
Showcase affidavit.
My lord.
Means what?
Yes,
whether compliant or not, order is complied or not.
Order has so far the opinion matter 1 is concerned, my lord. Achi noting the achina. Nice. We have filed a
71 more. Number 70.
No, e-filing, my lord, we are on filed on the 19 to 71.
71 more.
They say the compliance order compliance to be done by the university.
My lord, 71 I am there. 71, 72, 73. All matters are arising of same judgment that is dated 17/9/2025. Similar matter was before my lord in contempt, my lord, 13/2/2026. My lord, my learned senior advocate Mr. Mahapatra was there. Yes, all the matters are posted to 13/3/2026, my lord. I am praying that all the matters may come up on that date because the writ appeal is listed before Honorable Chief Justice on 23rd February, my lord.
23rd February.
My lord.
So we'll call this matter on 13/3.
13/3, my lord. All the matters are on 13/3, my lord.
Yes. What are all those matters?
Those matters are contempt number 5947.
No, see the serial number. It is not there today.
No, not that.
Not there. Now, what are the matters before me?
Before my lord,
71, 73.
71, 72, and 73, along with contempt case number?
Contempt case number 5947 of 2025 and 5948 of 2025 and 5949 of 2025.
25.
My lord.
On
13.3.
Madam.
On 13.3, 2022. Madam. Yes, next.
Okay.
Take this. This you have to put in that.
74, order dated 4/2026, issue police notice, my lord. Till date not order complaint.
Yes, sir, not notice. Await. Yes, sir.
We pray, my lord, more time to comply with lordship's order, my lord.
Lordship file so cause. My lord,
Notice issued on 4 February 2026, my lord. Pray more time to.
More time for what?
To comply with lordship's order.
You will comply with the order?
Yes, my lord.
Can we record that submission? They are saying that we will comply with the order. If they do not comply, seek a revival of these proceedings by moving an application.
Yes, ma'am.
Before this court room.
Yes,
The complaint alleges while non-compliance of the order dated 4/2/2026 entered in petition complainants WPC number
2099-0/2025.
No, order dated 2025 entered in WPC complainants WPC number 20990/2025. First off, after service of notice, the contemners are represented by the learned ASC Mr. Ray, who undertakes on behalf of his clients that the order in question would be complied with in letter and spirit within what days?
Within 4 weeks.
Within 4 weeks. First off, with this proposal, the counsel for the complainant is agreeable. First off. Next one, in the above circumstances, these proceedings are dropped with a warning that if the assurance given to this court today is not complied with, that would amount to aggravated contempt. And penal action, serious penal action would follow. And such penal action may include arrest and detention. In addition to levying the heavy fine in thousands of rupees, personally payable by the contemners. Yes, next.
75, I pray some time, my lord.
Compliance. Compliance of credit or compliance?
For instruction.
All right. Party number 2, which is your matter.
I am only praying that item 47 today in court I have just a supervision. This is on next sitting. Your lordship dropped it. I pray it for the next sitting because
49 we call in post
47.
13.3. They said compliance.
They have said today I have got it today only on court I have got it.
All right, 13.3. You recall that order. Huh? Yes, next. 75. 33. Stay.
75. Lordship, 75, Lordship, we have filed the complaints affidavit.
You have complied with that?
Lordship.
What's the complaint? Who appears for the complainant? Absent. Complainant's counsel absent. Complainant absent. Complainant's counsel absent. First of call on 33. Yes, Muslim.
76.
Pension matter. 2017, she has retired since 2007. Lordship directed to.
Yes, sir, notice not yet received.
Not yet received.
Await service of notice. First of call on 13.3. 23.3. Okay.
77 lordship last occasion lordship issue for police notice mail. Till date no.
But SR is not reported, na? Await notice. Call on 23.3. Yes. RSA, sir, the RSA, that matter, your matter. This will take some other day. Yes. We have some court meeting today.
Posted last hour because in the last hour we were not getting time. Enough time to close it. That's the only thing.
On 23, all right. On top of the list. And below. 23.3. 23. Yes. Agreeable. Yes. Call on 23.3. And at the top of the list. As requested by the parts. All right.